Suspension of sentence 9.1.
Appeal against acquittal also. Appeal against acquittal.
Appeal against acquittal है.
Yes Lord. ये जो सस्पेंशन वाला है ये सिंगल बेंच का है लॉर्डशिप. और ये जो मैंने क्रिमिनल अपील फाइल की वो अपील अगेंस्ट एक्विटल है. इसमें 302 जो ऑफेंस था उसको रिड्यूस करके 304 पार्ट 1 में कर दिया है. उसके अगेंस्ट है.
कौन सा आर्ग्यू कर रहे हैं?
गोविंद प्रसाद राठौड़ राम बाबू.
9.
यस लॉर्डशिप.
राम बाबू 9.1.
यस लॉर्डशिप.
9.1
पर ये सिंगल बेंच के लिए ये जो है ना सिंगल बेंच का 9.1 एंड 9.2. हाँ उसमें
एडमिशन हम लोग क्या लगता है
इसके साथ क्यों लगा
वो ये
9 बेबी का है.
दिस इज अगेंस्ट एक्विटल.
यस लॉर्डशिप. यस लॉर्डशिप.
ये तो दिस इज ऑलरेडी एडमिटेड 1410 को.
नहीं ये एडमिटेड नहीं है ना. मेरी वाली जो मैंने फाइल की 8741.
वी आर हियरिंग आइटम नंबर 9.
लॉर्डशिप.
यू आर एपरिंग ना.
लॉर्डशिप.
9 में बहस करिए गोविंद प्रसाद में.
यस लॉर्डशिप. मैं उसी
Why
में
you are confused? We are taking up item number 9. 9 is already admitted. This is admitted on 1410. List for final hearing लिखा हुआ है. You are not aware that appeal is already admitted.
8741 लॉर्डशिप.
हाँ 8741.
Yes, 8741.
मेरे नॉलेज में लॉर्डशिप फर्स्ट टाइम लिस्टेड.
आज एक्चुअली वो एडमिशन के लिए लिखा है ना इसलिए
Already
admitted है but it is wrongly mentioned in the call list your lordship therefore he is up.
This is already admitted. Yeah. This is against conviction, huh?
Yes लॉर्डशिप. Lesser sentence and acquittal for the two offenders.
Yes. So this is already admitted. क्या नोटिस नहीं गया क्या? क्यों मिस्टर प्रवीण 9 में एडमिट करने के बाद नोटिस नहीं गया? देखिए तो ऐसा लगता है नोटिस इसलिए नोटिस नहीं दिया. लिखिए श्री दिलीप सिंह कुमार फॉर द appellant MS Vinita Pai, government advocate for the respondent state. The appeal is already admitted on 14/10/2022. Will stop issue notice to the respondent. इसमें PF on payment of PF within 7 working days by both modes, returnable within 8 weeks. Available warrant जाएगा ना अगेंस्ट एक्विटल वगैरह है.
इसमें जो एक है उसमें भी सस्पेंशन की एप्लीकेशन है वो सिंगल बेंच में लॉर्डशिप के सामने लगेगा.
अभी केवल
We are taking up 9. Wait, we will take up.
Pardon.
अभी 9 तो कंप्लीट हो जाने दीजिए. क्या क्या ये लोग बेल पे हैं कि जेल में?
इसमें राम बाबू और ये नंदराम ये दोनों अभी जेल में हैं. बाकी तो सस्पेंशन हो गया. बाकी लोग
appeal preferred by Govind Prasad.
He is a complainant.
Respondent
इसे कंप्लेनेंट.
9 नहीं रेस्पोंडेंट का नाम राम बाबू और नंद किशोर जेल में हैं.
यस लॉर्डशिप.
बाकी लोग बेल में हैं.
यस लॉर्डशिप.
नंदकिशोर
तो इसमें एक भागीरथ सर और कालूराम.
ठीक है इशू नोटिस. यस व्हाट अबाउट 9.1?
ये सिंगल क्या लॉर्डशिप. 9.1 and 9.2.
So why they were connected? Arising out of the
Same
same
crime
crime.
number, therefore all these appeals are
This is also admitted.
Your Lordship, the reply in 9.1 I'm agreeing. The reply is awaited for the state, Your Lordship. The punishment is of more than 10 years. So if they
सस्पेंशन आगे के लिए रिप्लाई दिए अदरवाइज इट इज एडमिटेड ऑलरेडी
yes, sir.
रिप्लाई मैडम
Yes, Your Lordship, week's time में kindly.
लिखिए श्री यू आर अपीलिंग
मुझे इसमें ऑब्जेक्शन फाइल करना है लॉर्डशिप 9.1.
9.1 में श्री
Nitin Joshi.
नितिन जोशी फॉर द appellant MS Vinita Pai, government advocate for the respondent state Shri Dilip Singh Pawar for the objector
ऑब्जेक्टर
objector
गोविंद प्रसाद.
Govind Prasad
वरनामा फाइल करिए
है ना counsel for the objector prays for time to file wakalatnama and objection. Counsel for the state also prays time to file objection to the IA 13813 of 2022 full stop list after 4 weeks. वो एक लाइन डाल दीजिए the appeal is already admitted. Yes 9.2
इसमें सस्पेंशन हो गया लॉर्ड.
9.2 दीजिएगा फॉर एडमिशन है एडमिटेड है लिखिए श्री आप ही अपीलेंट के लिए हैं
नहीं लॉर्ड सत्यानंद चौबे.
लिखिए नन फॉर द अपीलेंट श्री MS Vinita Pai, government advocate for the respondent state Shri DS Pawar for the objector. The appeal is admitted. Is formally admitted. ये तो already admitted. Appeal is already admitted on 14/10/2022. List the matter for final hearing in due course along with the connected matters. Yes, Mr. Parihar.
Manoj, they have filed a reply on 111.
Come on,
On 1st November, they have filed a reply. We seek time for seeking instructions from the client.
To argue the application for condonation of
नहीं
delay.
सर कंडोनेशन वगैरह सब हो गया है.
हो गया है.
कुछ
हो
हमारे
गया.
प्रिलिमिनरी ऑब्जेक्शंस थे वो भी डिसाइड हो गए हैं.
लगा just a minute.
हाँ सर.
This is listed for condonation of delay.
सर वो
My lord, if you would see the order, kindly see
Yes,
the
sir.
order.
whatever my lord.
होगा
28/10.
When the application,
Sir, condonation of delay, sir, I suppose it is not, may not be reflected in the order sheets. So if they are seeking any adjournment, it may be heard on condonation of delay as well.
just we wanted,
Sir,
if the condonation is already decided,
sir,
then we will ask the registry to list it for
sir,
hearing on admission.
as my lord pleases.
But there doesn't seems to be any order on condonation of delay. There is one order
On maintainability.
on maintainability.
Yes.
Yes, my lord.
कितना डिले कितना है?
सर दो अलग अलग रिट अपील और रिव्यू के दोनों ऑर्डर्स चैलेंज किए हैं तो शायद करीब 60 डेज का डिले है.
60
तो
days.
सर दोनों चीजें एक साथ सुन लें, एडमिशन और एज वेल एज कंडोनेशन ऑफ डिले उनको उसमें जो प्लीडिंग्स आर कंप्लीट.
Yes. Shri
Abhinav Matra, my lord.
Sri Abhinav
Matra.
Matra for the appellant, Sri Prasanna Prasad for the respondent, counsel for the appellant prays for time to argue the application for continuation of delay. When do you want?
My lord, you may keep it in December.
List in the month of December 2022. किसके बिहाफ में खड़े हो रहे हैं मिस्टर मैत्रा? ऑन बिहाफ ऑफ श्री एस परिहार अटेंडेंस. यस.
Your Lordship, IN number 7684 for withdrawal of this writ appeal. It become infructuous as CEO Zilla Panchayat Dhar has passed in final order on my dismissing the present appellant.
So you want to withdraw the appeal?
Yeah, please, my lords.
लिखिए.
With liberty to file appeal against the order of CEO Zilla Panchayat Dhar.
There is an appeal provided against the order of the CEO, Your Lordship. The CEO already passed the order. Therefore,
Final
we
order.
withdraw this appeal. Written.
Yes.
हाँ.
In accordance with the law आप करिए जो भी है.
Please.
लिखिए.
Utkarsh Joshi, my lords, on behalf of Nilesh Agarwal.
श्री उत्कर्ष
Joshi,
जोशी on behalf of Sri Nilesh Agarwal for the appellant, MS Vinita Pai, government advocate for the respondent, heard on IA 7684 of 2022, counsel for the appellant pays for withdrawal of the present appeal in view of the order passed on 17/8/2022 by Chief Executive Officer Jila Panchayat Dhar dismissing the present. क्या आपको डिसमिस कर दिया कि अपील डिसमिस की? क्या अपील?
हम डिसमिस कर दिया है.
क्या आपको ही डिसमिस कर दिया सर्विस से?
Yes.
Dismissing the present appellant full stop. In view of the aforesaid, the present appeal is dismissed as withdrawn with liberty to the appellant to seek remedy against the order dated 17/8/2022 in accordance with the law.
Please, my lords.
Lords, on the last date we had sought time to file the additional reply, and it is in the vetting process, my lord. I seek another time
To file,
the additional reply.
लिखिए. श्री सिद्धार्थ धर्माधिकारी for the appellant, MS Vinita Pai, government है.
Yes, Your Lordship. Government is also part.
Government advocate for the state, none for the other respondents. Counsel for the appellant prays for and is granted 4 weeks time to file additional reply.
My lord, just fixed date may be
After 4
given.
weeks.
My lord, the fixed date may kindly be given as outstation counsel Mr. Vivek Khedkar is supposed to argue this.
When do you want?
Lords, if 16 December is
List on 16th December. Yes.
my lord, my presence for respondent number 1 may be marked.
Sri John Nunn for the respondent Tikal. Sri Amit Raj for the respondent number 1. Yes. Yes. None for the appellant. MS Vinita Pai, government advocate for the state. Case is adjourned.
Your Lordship, I am praying for Passover. The Army Council is on his legs. With a small child, he got sick.
Yes, कर दीजिए. पास हो. लिखिए. None for the
15 or 40.
yes 15.
I am appearing on behalf of respondent number 2.
Yes, for continuation of delay.
But there are two IAs, both I have replied. State की writ appeal है बोला.
Yes. Yes, who is for the state? This is a state appeal.
Miss Archana Kher is appearing, Your Lordship, in this case.
State के लिए.
She personally filed that appeal.
How can she file personally for the state?
When she was Deputy Advocate General.
Personally filed वकालतनामा along court-3 Sachin.
Then the appellant will be represented by you.
Yes.
If she has filed in the capacity of
पंचायत और स्टेट की इकट्ठी फाइल ही है सर. Sir, it will be taken up after 2 weeks. We will call the concern.
yeah, how
उन्होंने पर्सनल कैपेसिटी में कैसे फाइल किया?
No, but the state is the party through municipal
state-
secretary, the collector and the
this is
CMO.
wrongly filed.
Yes.
State collector and municipal
and
council.
Municipal council.
So municipal council should have filed.
Mr. Gajankush, make it clear
Yes.
whether state has also filed this appeal or not.
Yes. Yes.
Otherwise, we will ask to delete the name of the appellant number 1 and 2.
Yes.
We will treat the appeal only on behalf of municipal
Nagar
council
Palika. Yes. Yes.
if it is in personal capacity. I don't. Here, what I find,
Sir.
description is also made sometime very wrongly. State is through chief municipal officer,
Officer,
state
sir.
is like that.
Two authorities made complaint.
लिखे श्री उमेश गजांकुश एडिशनल एडवोकेट जनरल फॉर द appellant श्री ऋषिराज त्रिवेदी फॉर द respondent number 2.
2, my lord.
None for the respondent number 1. लिखिए council for the state please for time to verify whether the present appeal is filed on behalf of the state or not. List after 4 weeks.
This is the appeal.
Yes,
And similar to writ appeals are also there, my lord.
yes.
So if lordship would please to list these all writ appeals.
Yes, what are the numbers?
One is WA number 788/2018
Yes.
and another is WA number
WS 788 of 2018.
yes, my lord. This 2000, if lordship would please to consider the impugn order of this writ appeal.
Yes.
It is based upon the earlier order of the writ court, my lord.
Against that the writ appeal is
Is of 18.
18.
And now when the 2021 order was passed,
Yes.
then we have preferred two writ appeals against the two private owners, my lord.
Yes.
So
लिखिए
another is 1029, my lord.
10.
29/22 और आज लगी है 1030.
Yes. लिखिए श्री उमेश गजानकुश एडिशनल एडवोकेट जनरल फॉर द appellant श्री हिमांशु जोशी for the respondent number 1 at the request of counsel for the appellant list the matter for analogous hearing with WA 788 of 2018 and WA 1029 of 2021 22 कर दीजिएगा. वो क्या एडमिट हो गई है क्या?
नहीं, सभी अंडर एडमिशन.
ठीक है. Yes, Mr. Patel.
Wait, please, Your Lordship. My lord, this intra-court appeal, my lord, is directed against the order at page number 16, my lord, passed by the Honorable Single Judge, my lord, which though at first blush, my lord, appeared to be an interim order, my lord, but it has all the semblance of a final order, my lord. Inasmuch as the finding which has been recorded, my lord, has virtually rendered the writ petition allowed without hearing the respondent number 3, my lord, who is present appellant before your lordship.
Just wait, let us go through the order.
My lord.
So only they have been asked to file an affidavit.
Had it been so, my lord,
You
I would
did
have
not
no.
appear
No,
despite service of notice.
it was not in fact. That is why I pleaded in the writ appeal also
Whatever is
that
that,
notice
apply
was never
before-
served upon me, and coupled with the fact that this
But no order
finding.
is passed, Mr. Patne.
Just I would like to draw your lordship attention to the findings which has been given. What has the honorable single judge has held? That firstly, the writ of quo warranto has been filed challenging the authority of respondent number 3 to work an executive engineer in the cadre of DDA as well as IDA by way of deputation. I have reproduced the entire relief clause at page number 8 of writ appeal. Kindly see the relief clause first.
Yes.
Secondly, the honorable single judge has given a finding that admittedly, my lord, who has admitted, my lord? I was not there before the honorable single judge. It says admittedly his appointment and promotion both have been declared illegal by this court. It has never been so. I have brought on record all the orders.
observe.
This has been, and pursuant to this, my lord, the respondent number 1 has called upon me to offer explanation taking cue from this order of the honorable single judge, my lord. As if, my lord, the writ petition itself has been allowed by this interim order, my lord. And, my lord, several things, several orders of the state government of this honorable court has been suppressed by the petitioner. My appointment as assistant engineer has already been regularized way back in the year 2000, which order has never been challenged. I have been granted promotion in the year 2003 on the post of executive engineer with retrospective effect from 1994. Nobody has challenged it. Even final gradation list have been issued time and again, showing position as on 1/7/1995, my lord, showing me as senior to respond to the petitioner in the writ petition. It has never been challenged. The petitioner himself has not challenged his own regularization order or promotion order on the post of assistant engineer with effect from 1992. He is quite junior to me. Even then, my lord, this has been said.
All is open for you.
No, but the honorable
No
single
order
judge
is
has given
passed.
this finding, my lord, that admittedly
Mr. Nayak,
appointment and promotion both have
Just
been
wait.
declared illegal. My lord, where is the
Mr. Naik, what is the order against him? The court has observed that admittedly his appointment and promotion have been declared illegal by this court.
and government has not taken any action to remove him. Whereas the government, after this order, has transferred me to the
No, just wait, Mr. Patne. If there is any order, then there is any order in along with the writ petition
Holding the appointment of
of the
petitioner. My
respondent
lord,
number
the
3.
learned writ court has not given this finding, my lord. It has just reiterated what has
From
been
where
adjudicated.
it has come in the order.
My lord, we have,
Admittedly, his appointment and promotion have been declared illegal
yes.
by this court.
My lord, we have
You must
filed.
have filed some order of the court.
Yes, yes, my lord.
That's why the single judge has observed it. So where is that order?
My lord, it is annexure. Page 49 in the writ, my lord. Annexure P9, page 48.
P9. Respondent number 3 was party.
Yes, my lord.
This petition was filed by you.
Yes.
No, my lord. It was filed by one Mr. Anup Goyal.
No,
No,
it is
page
filed by me.
49.
It is filed by
Patne,
me.
first see the document. Then
It is filed by me. My lord, may kindly
Yes.
start perusing from para 8 onwards.
yes,
Para 9
yes. Para 9.
onwards, my lord.
Yes. This is regarding petitioner
No, my lord. It is point number 3.
as sub-engineer.
Para 10, my lord. So far as respondent number 3 is concerned.
He was appointed as assistant engineer. Where we get it that his appointment and promotion have been cancelled by this court.
My lord, who had this para 10, my lord. So far as respondent number 3 is concerned,
Yes,
respondent number 3 is present appellate.
yes.
He is concerned. he was appointed as assistant engineer ad hoc basis wide order dated 8/8/86 in TIT Khargone.
Yes.
And wide order dated 6/7/92 he was transferred to respondent number 2 DDA
Yes.
and had joined at Devas on 16/7/92.
Yes.
On appointment of number 3 in TIT Khargone,
Yes.
services of one Anup Goyal were terminated, who had filed miscellaneous petition number 105/87, wherein the present respondent number 3 was implemented as respondent number 6, the present appellant, my lord. And division bench of this court by order dated 11/1/94 had found the appointment of respondent number 6 therein as illegal.
Who is respondent number 6 in the
Present appellant.
present appellant?
Present appellant. He was in MP 105/87, he was respondent number 6. In this annexure P9, he was respondent number 3, and he is present appellant before my lords.
Yes. Very well. No order is passed. We will observe that the single bench will decide without being influenced by the order.
नहीं वो ठीक है वो ठीक है भाई.
Kindly allow me to narrate the facts because it is not so. Kindly see the.
No order is passed, Mr. Patne.
My lord, this
Single
finding.
bench has only
This is the
recorded
finding.
it's a content.
This is the finding, my lord, which has been
No,
recorded.
not finding. We will say that the single bench will decide without being influenced by the observation made in the order, yeah, whatever is mentioned in the order.
However, because my only anxiety is
It's an
this may be deleted from this.
Not
This finding
deleted. No
admittedly.
question of deletion. It's not a final order or finding recorded.
My lord, it is there, my lord. I have been called upon by the respondent number 1, my lord.
will say
Day after
this.
tomorrow, he has fixed the hearing, my lord.
Yes.
Based upon this interim order saying that the High Court has declared your appointment to be illegal.
Where is that communication?
My lord, that has received
No.
just now, my lord. I'll put before your lordship.
We will say the respondent number 1 will also act without being influenced.
Yes,
by
yes, yes. Very well, my lord.
My
Very
lord,
well.
my lord,
Very well.
my lord, page
Because
24.
ultimately it has to be decided this way or that way.
Yes.
Page 24 is the division bench order of this honorable court.
Page
24 of the writ record, my lord.
yes. 24.
This is annexure P5, page 22, starting from page 22.
Why did you not appear when notice was served?
Notice was not served. Notice was not served. I have mentioned in my writ appeal, my lord.
Yes.
Kindly see the acknowledgement which has been come before your lordship. Does not bear my signature at all. It has never been served upon me. Otherwise, I have no occasion, my lord.
Yes, Mr.
Page 27 is the operational part, my lord, conclusion part.
Yes. Yes.
Bottom, my lord, para 5, Roman 4, my lord.
Yes.
Since the appointment of the sixth respondent is illegal. This is the finding of the division bench of this honorable court.
Kindly mark the date also, my lord, of this order.
My lord, judicial orders cannot be wiped out by administrative orders, my lord. This is the judicial finding against which an SLP has been preferred before the Honorable Supreme Court. That has been withdrawn by the appellant, my lord. At the risk and cost of the appellant, my lord, or the taking the services, my lord.
Because after that, my lord, the state government has transferred me to Devas Development Authority, has maintained my lien in Devas Development Authority and regularized the services of the petitioner on the post of assistant engineer with retrospective effect from the date of initial appointment in the Devas Development Authority, and has also passed an order that my lien shall be maintained not in the TIT Khargone but in Devas Development Authority. All these orders have been suppressed from this honorable court. I have brought on record all those orders.
Yes.
And even after 2003, state government itself has given no objection to the Devas Development Authority for my promotion on the post of executive engineer. And after that, NOC, Devas Development Authority undertake DPC, has promoted me on the post of executive engineer in the year 2003 with effect from 6/9/1970,
Where is the
1994.
communication by the number 1?
Of
Number 1, you say that he has asked you to appear
yes,
before.
my lord, it is there in today just only, my lord. I
Yeah, what
received.
he has written in that?
My lord, I just read, my lord. My lord, can you keep it in the second order? I get a printout of the same, my lord.
And just read out.
My lord, all these orders have been previously considered by this honorable court as I showed in annexure P9. My lord, this is just the reiteration of the judicial orders which have been passed by the writ courts, my lord. It is not a finding, my lord, it is just a what is held
My lord, it
earlier.
reads thus, 2/11/2022 का है ये, and it has been received on 7/11. विषयांकित याचिका में माननीय उच्च न्यायालय खंडपीठ इंदौर द्वारा पारित आदेश दिनांक 17/10/2022 के परिपालन में, दिस इज द इम्पिन ऑर्डर, पालन में वरिष्ठता से संबंधित आपके पास उपलब्ध अभिलेख सहित दिनांक 1/11/2022 को 12 बजे उप सचिव सोइंसो विभाग में द्वितीय तल में उपस्थित होने का कष्ट करें.
Simply you have been asked to appear.
On the basis of this order. So my only submission before your lordship is, your lordship has rightly observed that since the writ petition is yet to be adjudicated by the honorable single judge, this finding should not all at all been taken into consideration by the respondent number 1, or for that matter by the honorable single judge decided the writ petition finally, because the very purpose of my tendering appearance and contesting writ petition would render infructuous, my lord, if this order is been treated to be an order treating me to be my appointment to be illegal and promotion, and nobody has challenged the promotion. My lord, the honorable single judge has said that my appointment and promotion both have been declared illegal. And this was so done in the year 1994. After that, in the year 2000, the government has regularized. Nobody has challenged it.
Yes.
And I have been given promotion. Nobody has challenged it. And on the out of blue, my lord, this order came to be passed by the honorable single judge saying that my appointment and promotion both have been declared illegal.
Yes.
State government itself has regularized me, rectifying the mistakes, my lord.
My lord, may I
And
submit
cause
one
was
thing,
what? Cause was what, my lord? On what premise the division bench has said that the appointment to be illegal way back in the year 1994, saying that the state government did not have authority to appoint me.
Yes, that is not final order.
Yes. And nobody at no point of time, pursuant to the orders of this honorable court, successively my promotion has been challenged by the respondent number 3 before this honorable court. At no point of time the honorable court had an occasion to deal the matter on the merits. Every time the state government has called upon to decide the matter, and state government has decided the matter in my favor, my lord, all along.
Yes.
But all this has never been brought to the notice of the honorable single judge. Unfortunately, I was not there, my lord.
Yes.
But since I have brought before your lordship for kind consideration all these documents, my lord, which speaks volume about my genuineness of my appointment and promotion, my lord. So at least they should have been all be looked into,
Yes.
and the honorable single judge be requested, my lord, that without being influenced by this observation, writ be adjudicated at an early date. We have no problem, my lord. But at the same time, the respondent number 1, who has called upon me to offer explanation pursuant to this order, he also may not be influenced by the observations so made by the state government, by this honorable court, my lord. This is the innocuous
My lord,
because
my lord,
every
may I-
person has a right to be heard before being condemned, my lord.
May I submit one thing, my lord? Whatsoever is the cases, my lord, it is firstly, my lord, this impugned order is not a finding arrived by the process of adjudication, my lord. My lords may kindly appreciate what we were attempting to read. I just read one paragraph, assuming that, my lord, it is the subject of satisfaction that earlier this honorable court has already held the appointment of the appellant to be illegal. My lord, if that is kept aside for a while, my lord, if that is kept aside for a while,
This
what
is not
does
the final order by the single.
absolutely not. Therefore, we
He
say
has
that
simply
the appeal is
recorded
not.
whatever was argued, and then he passed the order that principal secretary should file an affidavit.
Yes.
Why the action for
Yes, yes,
has not been taken in the matter.
yes.
So he will get an opportunity to.
He will get, my lord. There is
But
no occasion for filing this appeal, my lord.
this
Since it is not
admittedly
a
and
finding of fact or finding of
ठीक है.
adjudication.
My lord, this is said
Therefore,
admittedly.
We are not saying anything. We are saying only that the authority and the single judge
Yes.
will proceed without being influenced by the order.
Yes.
My lord, that's. My lords, if I may take my lords to one judicial order itself, my lord, which is passed by this
before the
honorable
single
court.
bench.
Yes.
whatever
We
you
have been
want.
arguing, my lord. It is a case, my lord, that the
So
appellant did
matter
not.
is pending before the single bench.
No, so this is not a finding, my lord. So even
So that's
this
we
kind
are
of
saying.
observation of my lords that
We are also
don't get
saying
in.
same thing, that it's
Yes,
not
this
a
is not
finding.
finding. This should not be treated to be a finding.
Yes, but my lord, this has been projected to be a finding by the appellant only.
ठीक है, it's based on apprehension, etc.
Maybe,
Not
Because
my-
the authority
maybe
has
I've
apprehension.
been called upon to appear before
No,
No,
respondent
that
number
is
one based on this
the
order.
administrative
Why
role to be played by the state government.
Why
No,
should
Your Lordship, it is not
prejudice?
administrative because there is a specific direction issued by this honorable court,
As
Your
to
Lordship,
why
by
I'm-
the
why-
impugned order.
as to
And
why-
therefore this explanation was called from
Yes,
the
yes.
press number.
He will consider all the contentions raised by
Yes,
the
yes, Your Lordship.
appellant. लिखिए श्री LC पटने learned counsel for the appellant MS Vinita Pai, government advocate for the respondent number 1. आपका नाम?
अग्रवाल for respondent number 2. Ishita Agrawal.
MS Ishita Agrawal for the respondent number 2. Sri Aniket Nayak for the respondent number 3. The present inter-court appeal is filed against the interlocutory order dated 17/10/2022 passed by the single judge in WP 13789 of 2020. Full stop. The learned single judge has passed the following order. ये यहाँ से फ्लैग कर दिया है, यहाँ से यहाँ तक ले लेंगे. लिखिए. Counsel for the appellant, who is respondent number 3 in the petition, submit that in view of the order dated 17/10/2022, the respondent number 1 has issued letter dated 2/11/2022 received by him on 7/11/2022 seeking explanation. कब आपको मिला कब है?
7/11 को
7/4
उसके ऊपर लिखा है 2/11.
अच्छा, अभी तो आया ही नहीं. माय फ्रेंड
नहीं 7/11 को अपीयर होना है.
अच्छा, आपने कहा ना कि रिसीव्ड.
नहीं एक मिनट, वो गलती हो गई. वो 7/11 को अपीयर होना है. 7/11 को अपीयर होना है लॉर्डशिप. 2/11
ठीक है.
नहीं है,
डेटेड
7/11 बजे उपस्थित.
2/11/2022 whereby the appellant has been directed to appear before the said authority on 7/11/2022 along with his explanation. Full stop. It is submitted that notice was not served to the appellant and therefore he could not appear before the learned single judge. It is further submitted that the respondent number 1 has treated the interim order dated 17/2/2022 as a finding recorded by the court regarding the appointment and promotion of the appellant. Full stop. Likhe, counsel for the appellant disputes the fact that his appointment and promotion have been declared illegal by this court. Full stop. He submits that in view of the subsequent order, by the respondents.
Yes, my lord. State government itself.
By the respondent number 1, the efficacy of the termination, efficacy of the impugned order declaring his appointment and promotion illegal has been lost. Full stop. It is further submitted. लिखिए, counsel for the respondents submit that the aforesaid नहीं, एक लाइन और डाल दीजिएगा. Therefore, the present appeal is maintainable as in view of the law laid down by the full bench in the case of Arvind Kumar Jain versus State of MP and others, 2007 volume 3 MPLJ 376, because the interlocutory order is having color of the final in nature.
But your lordship has observed MPLJ, it is MPHT, my lord.
MPHT में है
जी.
MPHT कर दीजिएगा. लिखिए, counsel for the respondents opposes the prayer on the ground that the learned single judge has passed only interlocutory order directing the respondent number 1 to file an affidavit before the court that why the order of this court has not been complied with. Full stop. The order is only interlocutory in nature and no finding has been recorded by the learned single judge. After hearing learned counsel for the parties, we deem it proper to dispose of the present. After hearing learned counsel for the parties, we are not inclined to entertain the present appeal against the interlocutory order. However, it is observed that the respondent number 1 shall take a decision on the explanation of the appellant without being influenced by the order dated 17/10/2022. Full stop. The learned single judge shall also decide the matter on its merit without being influenced by the order dated 17/10/2022. With the aforesaid observation, the present appeal is disposed of. Public. Yes, Madam Mukherjee.
डॉक्यूमेंट्स रिकॉर्ड पर लेने के लिए एक आवेदन फाइल किया है
क्या
7151
admitted?
नो योर लॉर्डशिप इट इज नॉट एडमिटेड इसमें मुझे अमेंडमेंट करके कुछ ग्राउंड्स और ऐड करना है जो बहुत इंपॉर्टेंट है और छूट गए हैं
Want to make amendment in the appeal?
लॉर्डशिप इन ग्राउंड्स
This is intra-court appeal. You can't go beyond the pleadings.
लॉर्डशिप पिटीशन में वो सब चीज़ थी लेकिन अपील में रहने से रह गई है और ऑनरेबल सिंगल जज का जो फैसला है उसमें भी उस ग्राउंड्स के ऊपर कुछ रिलाई नहीं किया और जजमेंट
अगर आप डॉक्यूमेंट पे रिलाई कर रहे हैं तो फाइल रिव्यू. If those documents were not filed before single bench and you consider that it can change the judgment, then file review before the single bench. Otherwise, argue on merit.
लॉर्डशिप काइंडली गिव 1 week टाइम टू आर्ग्यू द मैटर काइंडली लिस्ट आफ्टर 16
Time. क्या मेरिट पे क्या है?
अच्छा मेरिट पे मैटर ये है कि पिटिशनर जो है वो
What
पटवारी के पद पे अपॉइंट हुए थे 2000 में रिटायर हुए और 1/1/2006 से 6 पे कमीशन लागू हुआ और 6 पे कमीशन लागू
petitions have been decided.
यस लॉर्डशिप बट इसमें कैलकुलेशन का मैटर इन्वॉल्व है पिटिशनर के 5 इंक्रीमेंट इसमें इंक्लूड नहीं किए गए हैं और उसके कारण जो है पिटिशनर का लास्ट पे रॉन्गली कैलकुलेट किया गया है जिसके आधार पर उसकी पेंशन भी काफ़ी कम है ये सब आधार उसने रिप्रेजेंटेशन में लिए हुए हैं इस कारण से मैं इसमें अमेंडमेंट करना चाह रही थी कि वो सारे ग्राउंड्स अपील में भी लेना अनिवार्य है
वो आप रिव्यू फाइल करिए ना अगर आपके हिसाब से those points have not been considered or some documents. Writ appeal का scope is very different, limited. We can't go beyond the pleadings and the arguments whatever has been submitted before the single bench. If you consider, we will grant you liberty to file review. लिखिए MS Manjula Mukati, learned counsel for the petitioner appellant. MS Vinita Pai, government advocate for the क्या सभी respondents?
Yes, sir.
For respondents, लिखिए counsel for the appellant.
लॉर्डशिप काइंडली एडजॉर्न फॉर 1 week मैं एक बार कंफर्म कर लेती हूँ
अरे आप डॉक्यूमेंट्स फाइल कर रही हैं
फाइल तो कर दी डॉक्यूमेंट्स में
तो उनको सिंगल बेंच के सामने लाइए ना रिव्यू के माध्यम से व्हाटएवर वेदर इट इज अलाउड और ये लिखिए द रिट पिटीशन फाइल्ड बाय द अपेलेंट ऐसा लिखिए काउंसिल फॉर द अपेलेंट क्या अमेंडमेंट भी लगाया है क्या आपने
नो लॉर्डशिप
नहीं सर
Only
only
application
IS
for taking
7151 your lordship of 22
लिखिए काउंसिल फॉर द अपेलेंट submits that certain circulars could not have been brought to the notice of the learned single judge and those circulars are being sought to be filed before the appellate before this court wide IA number 7151 of 2022 लिखिए full stop. If those circulars have not been filed before the learned single judge for consideration, comma, the same cannot be a ground for appeal. Full stop. At this stage, counsel for the appellant prays for withdrawal of the appeal with liberty to file review before the learned single judge along with the relevant circulars. Full stop. The prayer in view of the aforesaid, comma, the appeal is dismissed as withdrawn with the aforesaid liberty. Yes.
So there is a matter pertaining to transfer. The petitioner has been serving, my lord, on the strength of the interim order passed by this honorable court. It's been more than a year, my lord. It may be quashed because the government is not coming up with the reply, my lord. Liberty may be granted to them to file, pass a fresh order in case need so arises, because this is a matter when I have been transferred to a
This has been
non-Urdu
stated in the
school.
appeal.
Yes, lord.
Yes, Your Lordship.
Where is the stay order?
On 24 22/12/2021, my lord.
22.
12/2021.
May I submit, Your Lordship?
Just a minute. Considering the peculiar circumstance where the medium of instruction is Urdu, who is posted at Hindi school, allowed to continue in the government Urdu primary school, Yadav Colony, Ujjain. Yeah, you are a Urdu teacher
My lord.
and you have been transferred
To a non-Urdu school.
non-Urdu. There is no Urdu subject.
Yes, my lord. It has been pleaded specifically. It is the timetable itself was brought on record.
ये कैसे होगा ये तो
No, Your Lordship. In the impugned order itself, Your Lordship, the learned single judge specifically held, Your Lordship, his appointment is on this post of the science teacher, Your Lordship. And the language is Urdu, Your Lordship. But in the appointment order, only science teacher he was mentioned, Your Lordship.
No, if the language is Urdu,
Medium of instruction is Urdu. Even the answer scripts are written
My
in Urdu.
reply is under preparation, Your Lordship. 2 weeks time may kindly be granted, Your Lordship. I will file the reply in the appeal also, Your Lordship.
the medium of instruction is
Urdu, and even answer scripts are written in Urdu script, my lord. Even the textbooks are in Urdu. And the principal has written a letter, my lord, that on account of the transfer of the petitioner, nobody would be there in the school.
कैसे discharge कैसे करेंगे? Your government is insisting his medium is Urdu.
But
There-
his
whether
substantive
there are
post is a science teacher, Your Lordship. And therefore he can be transferred in any other school, Your Lordship.
Ye-
It is not a case wherein, Your Lordship, he was
there are
appointed
no
in.
schools having Urdu medium.
I have no instruction at present, Your Lordship. Therefore,
There
2 weeks
are
time may
schools-
kindly be granted, Your Lordship.
What the principal is writing, my lord, उपरोक्त विषय
There is
अंतर्गत
already
निर्णय-
an interim order in his favor, Your Lordship.
You want to contest the matter,
Yes, yes, Your Lordship.
or if you say we can give you liberty,
No, Your
You
Lordship.
should
Kindly,
press
kindly
transfer
grant
order.
me 2 weeks time, Your Lordship.
लिखे श्री पटने learned counsel for the appellant MS Vinita Pai, government advocate for the respondent, the state prays for and is granted 4 weeks time to file reply interim order to continue.
अपॉइंटमेंट लेटर कहाँ है? अपॉइंटमेंट लेटर
Sir, अभी reply file कर रहे हो. Therefore, I am praised for time, Your Lordship. There is
ठीक
a
है, file
specific
करिए.
order of appointment, Your Lordship.
And against the notice. Yes, Mr. Kutumle.
My lord, against the notice issued for demolition of alleged illegal construction, I
Yes.
filed a petition, and my petition has been dismissed. Now, during the
Petition has been
pendency of the
dismissed.
petition, an application for compounding was filed before the corporation.
Yes,
I'm paying for the corporation in this case.
you are appealing for the corporation. Yes. Where is the order passed by single bench?
P70, A1 panel, page 17.
Page 17. So, have you filed any reply to the notice?
I moved an application for compounding.
No, whether compounding is permissible under such?
Yes, yes, it is permissible. 788A gives permission. There are three judgments, my lord, I relied. One of the honorable single bench. Now, when I pointed out on the earlier date, this judgment passed by the honorable single bench in one of the matters. My learned friend objected to that this judgment has been distinguished. But on the contrary, these judgments have been confirmed by two honorable division benches. And this is judgment passed by the honorable single bench. Now, in the same order, an appeal was preferred.
No, no, this is all not considered by the single bench.
Yes, my lord.
This all was not argued.
So this was, if I may be allowed to submit, Your Lordship, this was not the bone of contention in the writ petition, Your Lordship.
Yes, that's
After the writ petition, Your Lordship, a review petition was filed, whereby on the strength of the compounding application, the review petition was filed that their application of compounding may be considered, Your Lordship. And in that review petition, the grounds that have been raised in the writ appeal, Your Lordship, no ground was raised in the review petition, Your Lordship. And by this appeal, Your Lordship, they have only challenged the order of the writ petition, they have not challenged the order of the review as well, Your Lordship. And that is
review
why
has also been dismissed.
review has been dismissed, Your Lordship.
By which order?
Review has been dismissed by
19, my lord.
Page 157, annexure 8.
157.
order dated 7/1/2022, Your Lordship.
Title is Para 2, my lord. Modified by granting liberty to the petitioner to apply for compounding. And the application is filed by lord. The right to apply for compounding is an independent right for which the petitioner is always at liberty to apply in accordance with law, for which no direction is required, is no case for review.
Yes.
A11 is the application, my lord, page 159.
So have you applied for compounding?
Yes.
A11, page 159.
Page 159, my lord.
Yes. What happened to that application?
It is pending.
Lordship, that is pending.
take a decision. We will take up this matter. You first decide their application.
Your Lordship, we have since they have not replied to the notice, the initial notice also, Your Lordship. The notice was sent to them stating that a notice was sent to the appellants, Your Lordship, stating that they may submit the sanctioned layout plan as well as the permissions, Your Lordship. That has not been submitted till now, Your Lordship. Now, even in absence of that, that compounding application also
Mr.
cannot be
Kutumble,
decided. Your
any
Lordship.
document to show what is your case, whether you had taken permission.
No, my lord, even then, my lord, the application for compounding is maintained. You 100% illegal, my lord, this judgment 2019. That lays down the principle. And this has been confirmed by two honorable division benches, my lord.
If I may be allowed to submit, Your Lordship, these are the orders passed in the division bench, Your Lordship.
The same judgment has been confirmed by our division.
Against the same order of writ petition, Your Lordship.
Yes.
If Your Lordship may kindly see paragraph number 2 of this order, Your Lordship, at the bottom.
Yes.
I am reading from the beginning of paragraph number 2, Your Lordship. Shri Aniket Naik, Learned Counsel appearing for the Indore Municipal Corporation, while arguing the writ appeal, has stated before this court that the observations made in the judgment will come in way of the authorities while deciding the representation, as it has been held that the petitioner is entitled for compounding in light of the rules framed on the subject known as Compounding Rules 2016. He has stated that it is a case where there is no layout sanctioned by Town and Country Planning Department, which is a mandatory condition, nor at any point of time building permission was granted. And then, on the other hand, an attempt has been made by the Learned Counsel appearing for the respondent in the present writ appeal to establish that the case has been compounded. However, the fact remains that there are certainly observations made by such and such which will certainly come in the way of authorities in deciding the matter. Resultantly, with the consent of parties, the matter is disposed of. It is made clear that that while deciding the representation of the building owning, the observations made by the learned single judge will not come in way of the corporation, and corporation shall be free to decide the matter independently in accordance with law.
Yes.
So this is also a case, Your Lordship, where in my humble submission, Your Lordship, they do not have any sanctioned layout plan or any permission from the corporation, Your Lordship, to raise that construction. And that is what we have been calling upon them to submit those
Why you are
permissions.
not deciding this application for compounding?
Because they have
This
not
is
submitted.
in January.
They have not submitted any documents, Your Lordship.
No, reject it.
File before the building officer, my lord.
Reject it, so that their only contention is that they are not saying that they have got any building permission, etc. They are saying that their application for compounding is pending. You decide it this way or that way. We will take up it after you decide the application, because that only contention is that much. Otherwise, commissioner report was also called.
Yes, Your Lord.
The commissioner says that he has not said whatever was the direction given by the honorable bench. The commissioner has observed something otherwise. He has not said that construction is going on.
No, that is the arguments which has been raised by the senior counsel, my lord, that is contrary to the entire pleading, my lord. What has been pleaded in the writ petition, my lord, and what has been argued before this court. The pleadings are that he is not raising any new construction. He is just doing a repairing work. And he is the owner of the property. That pleading was also mentioned in the writ petition, my lord. Now the 2019 judgment, my lord, will please to consider, my lord, the 2019 judgment which the learned senior counsel is relying, my lord. The facts of this case, my lord, that he is the owner of the property. He has the permission to construct the 3-floor building, but he, instead of constructing the 3-floor, my lord, he has constructed the 5-floor, my lord. So the court says that no, since he has constructed the buildings which is not sanctioned by the Town and Country Planning and not according to the...
Is that the construction in the present case is without any permission at all?
My lord, the notice has been given by the corporation saying that submit documents of the ownership and building permission and the sanction map. This was the notice, my lord.
Yes.
So neither he has submitted the documents with regard to the ownership of the property,
Yes.
nor he has submitted any sanction map, and nor he has submitted any permission from the corporation, my lord. And this was not the pleading, my lord. The pleading was he is not raising any new construction. Then the commissioner was appointed because we have he has got the status quo order, and we have raised the objection that instead
You
of
are for the intervener.
yes, my lord.
You are claiming title over the property.
Yes, we are the owner of the property that was held by the 1959 my lord judgment.
So
And
who has prevented you? You get the title, your title, etc. It's only between that regarding the illegal construction.
but my lord, we are the owner of the property, and
No, we will not decide the ownership in this petition. This is not a petition for ownership. He has challenged the notice of the corporation, and the corporation has found that the construction is without permission.
since my lord he has come with the pleading, my lord, that he is the owner of the
We,
property,
at the
therefore we
moment,
have
We
entered
are
into
only
the
concerned
petition,
with the
my lord.
main contention that application for compounding is filed. And since
that-
January 2022, this application, it may not be that the compoundable.
Lordship, this, if I may be allowed to submit,
Yes.
this application was filed on 11/1/2022, Your Lordship.
Yes.
And then on 10/2/2022, this writ appeal was filed, Your Lordship, and they
Yes.
have obtained a status quo order in this
We
writ
will
appeal. Your Lordship.
observe that the corporation would be free to decide.
Yes, sir.
Order of status quo would not come in the
We'll decide the application in the meantime, Your Lordship.
within 15 days.
15 days.
Whatever time you say, we will fix it after that period. Whatever you say that it will be decided within 15 days.
We'll decide within 15 days.
लिखिए श्री A.S. कुटुम्बले सीनियर काउंसिल with श्री B.S. Gandhi for the appellant, श्री State M.S. Vinita Pai, government advocate for the respondent number 1, श्री Manu Maheshwari for the respondents 2 and 3, श्री अखिल गोधा डायरेक्ट काउंसिल. क्या आपने इसमें भी लगाई है इंटरवेंशन?
उनकी इंटरवेंशन तो अलाउ भी नहीं हुई थी.
My intervention, I have been
It was
treated as
not
a
allowed.
respondent, my lord, in this case, my lord.
अपील में
In the
Petition, my lord, the application for intervention was not allowed at all.
so he says that it was not allowed
Yes.
in the writ petition.
but I have been treated as a respondent, my lord.
No, no,
Your
here
lordship
I
will
had
please
to.
to
Since you appeared before the writ
In
court,
the appeal where you are a respondent,
Lord, I have
See-
not been made as a respondent, my lord.
so have you applied for intervention in the appeal?
no.
My lord, may kindly consider the page 18, my lord, the order.
No, only presence. But the
I have been treated as a respondent intervenor, my lord.
where?
Akhil Godha, learned
अरे ये
counsel
तो
for the respondent.
लिख देने से you will not become respondent unless you show that any order.
Lord,
that you
I'll file the application again, my lord.
लिखिए for the intervener, proposed intervener in the writ petition. अभी आपने फाइल नहीं किया ना writ appeal में. लिखिए the present appeal is filed. Mr. Kutumble, one objection is also there that you have not challenged the order passed in the review petition. Examine that. Today we are not deciding that issue.
I will check it.
लिखिए
This is
the petitioner filed a writ petition against the notice dated 25/6/2021 issued by the respondent corporation calling upon the petitioner to stop the construction, failing which the same shall be demolished. Full stop. The writ petition has been dismissed on the ground that the petitioner has raised construction without permission of the corporation. Full stop. Counsel for the petition appellant submits that the appellant has filed an application for compounding under the provisions of Madhya Pradesh Municipal Corporation Act and the rules framed therein on 11/1/2022, and therefore the respondent corporation be directed to decide the said application first before adjudicating the present appeal. Full stop. In support of his contention, he has placed reliance on a judgment passed by single bench in the case of Ramesh Verma versus Indore Municipal Corporation 2019 Volume 1 MPLA 69, where it has been held that if the construction is raised without permission and if the application for compounding has been filed, comma, the said application has to be decided on merit in terms of the compounding rules. Full stop. Counsel for the corporation submits that the application filed by the appellant for compounding could not be decided by the corporation because of the interim order of status quo passed by this court on 10 to 2022. 10 to 2022 till the next date of hearing status quo. लिखिए. After hearing learned counsel for the parties, comma, the corporation is it is made clear that the order of status quo passed by this court would not come in the way of the corporation to decide the application for compounding dated 11/1/2022 in accordance with the law. Counsel for the respondents corporation submit that the aforesaid application shall be decided within period of 15 days from today. List the matter on 25th November.
2nd of December. 2nd of December.
2nd of December. 2nd December.
I have some difficulty on 2nd.
25th sufficient time, Mr. Kutule. Kafi. It is almost more than 3 weeks and something. 25/11/2022 interim order to continue.
Lordship, they may be directed to supply to file the requisite documents within 3 days.
Yeah,
No, I will file it, my lord. Whatever documents I have, I will file it.
वो जो जहाँ लिखा ना 15
After giving me an opportunity, my lord, of course.
in accordance with the law कह दिया है. लिखिए, if the appellant जहाँ पे 15 days लिखा है, if the appellant wants to file additional documents, the same shall be filed within 3 days from today.
The receipt of the copy.
From 3 days from the receipt of the copy of order passed today.
It is well within their knowledge only, Your Lordship, that this order is passed. They may just file the documents.
7 days कर दें आपको. वो काट दीजिए. The petitioner, it would be open for the appellant to file additional documents, if any, within period of 7 days from today. Yes.
Obliged.
Yes.
But initially, I had challenged the order passed by the state government,
Yes.
the PS transport, whereby an order has been passed saying that the existing route operators at the time of grant of permit will not be given a chance of hearing. That order was under challenge. Now I relied upon about 5 judgments passed by this honorable court. There is the competent division bench judgments which say that the existing route operators have a right to challenge the grant of permit. My petition was dismissed, my lord, saying that no, there is a judgment passed in 2019 and which says that the existing operator does not have any right. I prayed before the learned single bench at the matter, since there are two divergent views. One says that right is available to existing operator, the other says that no right is available. the matter will be referred to larger bench. That prayer was also dismissed. And thirdly, my lord, I relied upon a judgment of the larger bench of this honorable court, in which it has been held that the judgment passed in the earlier matter would prevail. That has not been considered at all. So my submission is, my lord, since there are two views available, the matter deserves to be referred to larger bench.
We will hear that. What is the urgency?
नहीं है, urgency कुछ नहीं है.
We admit it. We will.
तो ये admit करके stay दे जो अभी सुनवाई हो रही है. इस वजह से करते हैं.
देखिए श्री A.S. कुटुंबले senior counsel with Sri. Yes, you are appearing Mr. Kutumble with what is
Abhay Jain. Abhay Jain. Abhay Jain.
Abhay Jain. Sri Abhay Jain for the appellant. Sri Nair, Deputy Advocate General for the respondent state. क्या कोई interim order है क्या?
इनके status को दिया? नहीं.
The appeal is admitted for final hearing. List in the due course. Yes.
Grateful.
So, एक judgment, Mr. Nair, I also delivered in the DB.
Yes.
With Justice Jha, I remember.
My lord, the judgment, there are two, they say that
Perhaps
there are two
remedy of appeal is not there, but remedy of revision, as what I remember.
under section 90.
We held that
Well, the point what they are raising here is that in the 1939 Act, there was no provision under 47 and 50. It's, after the insertion in 1989, 47 and 50.
This point,
yes.
They have
No, what I don't know right or wrong, but what we decided that you existing operator has no right to file appeal. You can challenge this order in a revision.
Correct.
Not in the appeal.
Appeal or revision होती agreed.
Yes.
No dispute about that.
We will decide that this.
And the sole interest was like the person who is not affected. Apart from that, these persons may not object to every.
आप बोलो से बहस तो करो उस मेरिट पॉइंट पे.
कोई गर्ग का जजमेंट है ना?
मिथिलेश गर्ग.
मिथिलेश गर्ग. We will decide that. Yes.
Your Lordship, 2 points of determination. 14.
14 Passover.
Yes, Your Lordship. There are 2 points of determination, Your Lordship. First is when any government employee.
Just a minute.
Yes.
14.
On 28th of October 22, Honorable Court passed an order on the point of limitation, condonation of limitation.
There is delay also.
That has been condoned.
Delay has been condoned on 28th of October 22 separately.
Now, Your Lordship.
Just a minute. 28th
October 22. The last paragraph is mentioned it.
Yes. Yes.
Your Lordship, 2 unified
Where
points
is
of
the
determination.
order passed by under single judge?
That is at page 10.
Yes.
Your Lordship, just the issue which I may narrate, that is a very, Your Lordship, elementary issue.
Yes.
When a government employee who was terminated solely because of his conviction in a criminal case
Yes.
gets acquittal in appeal, whether he'll be entitled, number one, for the back wages for the period he was kept out of the service. Number two, whether his services during that period he was kept out would be considered as continuity in service for all other benefits.
Yes.
Now, for the as far as the first issue is concerned, Your Lordship, my prayer is limited to the back wages from the date of acquittal, not before that. So from the date of acquittal till the date he was reinstated, my prayer is only limited to that period.
No, just let us see.
Yes, I'll just narrate the dates, Your Lordship.
Yes.
On 26/1/1997, FIR was lodged.
26/1.
1997.
Yes.
FIR was lodged against the petitioner who was
What
working.
was the offence?
Your Lordship, offence was 323.
323.
Yes.
Yes.
He was working as constable in railways.
Yes.
Then, Your Lordship, in the year 1998, January, petitioner was convicted and sentenced to undergo 1 year imprisonment.
Conviction.
Yes, 1998. On
Yes.
13/1/1998, he was dismissed from service solely because of his conviction.
Yes.
No department inquiry of any kind was conducted because 323 was alleged to be committed out of his service, not in the course of service.
Yes.
Thereafter, he preferred appeal before the High Court, and the Honorable High Court on 7/3/2017 acquitted him on merits. That was an honorary acquittal. Immediately thereafter, he applied for his reinstatement.
Yes.
Though he was not reinstated, and on 9/11/2017, his application for reinstatement was rejected by the respondents.
Yes.
Then he preferred writ petition, and this writ petition on 14/12/2018 was allowed by the Honorable Writ Court.
14/12/2018.
2018.
Yes.
In this order, Your Lordship, it was found that the acquittal is on merits, honorary acquittal. Thus, he is entitled to be reinstated. Second, there was no ground for the respondent to deny him reinstatement because dismissal was solely based on the conviction. And
Yes.
once conviction is set aside, there remains no ground for dismissal, termination from service. This was, however, Your Lordship, in that order, his back wages were denied completely. Now I'll come to that order. It starts from page 10.
Yes.
The relevant portion for the appeal.
Yes.
From para 10.
Yes.
The respondent has rejected the representation of the petitioner only on the ground that the state may go to higher court for review or in appeal before the apex court against the acquittal. But now, more than 2 years have passed and till today no appeal has been preferred.
Now your grievance is only regarding the
Back wages and
Back wages.
continuity in service. Now that para is para 9, Your Lordship.
Whether continuity in service is also denied?
Your Lordship, though it is not denied, but because of the vagueness in the order, they have deemed it to be denied.
No. What order they have passed
Yes.
after this order?
Yes, Your Lordship. I'll come to, first of all, I'll read the para 9 and then I'll come to their order.
Yes, we have read the para
Yes.
9.
Now, what order they have passed is, Your Lordship, the order is at page 18.
15 para 9.
Para 15 is the first, Your Lordship, where they have reinstated. That is a 2-line order at page 16.
Yes.
Where they have simply reinstated. Now, when, Your Lordship, the petitioner was treated as fresh appointee and basic
Where
salary.
is that piece? Reinstatement?
That is at page 16, Your Lordship, just a 2-line order.
Yes.
श्री जेंद्र पाल सिंह कांस्टेबल जीएस नंबर 05017 की ड्यूटी पर पुनः बहाली होने पर उक्त बल सदस्य के
Yes.
पोस्टिंग आदेश होने तक इन्हें रतलाम पोस्ट पर ड्यूटी तैनात किया जाता है तो सक्षम अधिकारी का अनुमोदन प्राप्त. This is the only order.
Yes.
Now, this was passed on 8/3/2019.
Yes.
After his reinstatement, Your Lordship, he was treated as fresh appointee and neither benefit of seniority was given, nor other increments were given, nor the salary which was due to him was given. As a fresh appointee,
Where
the
is
basic
that
salary.
order?
Now, he filed a representation that he is reinstated, not appointed, and they passed an order at page 18, 26/5/2021 dated. Married, Your Lordship.
Yes.
उपरोक्त विषय में लेख है कि कांस्टेबल जयेंद्रपाल के वेतन विसंगति के संबंध में की गई कार्रवाई के संबंध में क्रमिक विभाग का परामर्श लिया गया व उनके द्वारा दिए गए रिमार्क निम्न प्रकार है. As the Honorable High Court has already mentioned in its order that he is not entitled for back wages on the principle of no work no pay for the period between date of dismissal and date of reinstatement cannot be count for the purpose of MSCPs. However, if he completed qualifying service for MSCPs before his dismissal, then he may be granted financial upgradation under MSCPs as per rule. As mentioned period is treated as no work no pay, hence will not be added for the purpose of determining qualifying service. Hence for the MSCPs APAR are essentials which may not be applicable for no work period. Due to these reasons his claim for MSCPs may not be processed. वेतन निर्धारण निम्न प्रकार से किया गया है. मूल वेतन बर्खास्त दिनांक 13/1/1998 को 3,425 रुपए. देन योर लॉर्डशिप ये सातवें वेतन में आई एम कमिंग डायरेक्टली टू लास्ट पेज. सातवें वेतन आयोग के अनुसार लेवल 3 में न्यूनतम वेतन 21,700 निर्धारित है, जिसके अनुसार उक्त कांस्टेबल को दिनांक 8/3/19 को सेवा में बहाल होने पर रुपए 21,700 निर्धारित किया जाता है. कांस्टेबल का वेतन निर्धारण माननीय न्यायालय के he is not entitled for back wages on the principle of no work no pay.
Treated to be a fresh appointment.
Yes. तब न्यूनतम salary is given to me. Fresh appointee is given the minimum salary which is there.
Whether this order can be subject matter of challenge of the writ appeal.
Your Lordship, what I
You
am
have to file a fresh petition.
Fresh petition he is going to challenge this.
I am assailing the findings of denial of back wages. If that is washed away and that has been considered, then automatically this order will not
Yes,
hold its
under
force.
which law you are entitled for back wages?
Yes, Your Lordship. Now, as far as the back wages in the cases of reinstatement on acquittal are concerned, the law is very clear, Your Lordship. I'll first of all, Your Lordship, rely on the judgment of this court. That one copy is already there.
Yes.
This is
Which judgment says?
This is the judgment delivered by the Honorable Single Bench, where the exactly same issue was involved.
Single bench.
Yes. They have still that have persuasive value that has not been challenged. Now, in this case, also in the criminal appeal, the acquittal was given. The petition was denied. Reinstatement.
Nothing has been decided by the single bench.
Your Lordship,
it's only a direction.
No, that has been decided.
Whether law is decided by Supreme Court.
No, yes, Your Lordship. Two things are decided in this case
That we
also.
are asking. This is simple and order.
Your Lordship,
whether law has been decided in a case of acquittal.
Yes, Your Lordship. That has also been
entitled for back wages.
Yes, that has also been decided by the Honorable Supreme Court as well. Two things have to be given on acquittal. First is the back wages from the date of acquittal, and second is the continuity in service. The law laid down in this case has been relied recently by the Honorable Supreme Court.
What has been decided? Where the issue has been considered by the Supreme Court?
Your Lordship, the reasoning has been given that when the acquittal is given on merits, the only basis of termination is gone. A termination stands baseless. The person is entitled to reinstatement. That too, his services would be considered in continuity without any break, and he would be entitled for back wages from the date of acquittal. Now, this law has also been relied recently by the Honorable Supreme Court. in the judgment I just handed over, Your Lordship, this of 2019, there the court was dealing with the issue where the High Court had granted 100% back wages from the date of termination. The Supreme Court has held that the petitioner would be entitled for the back wages from the date of acquittal along with all other service benefits, that too for the period he was out of the service. Except the back wages, he would be entitled for all other benefits from the date he was dismissed. Your Lordship, the jurisprudence behind this is that once the conviction is gone, the basis for the termination is now baseless, and that is why the petitioner is entitled to be reinstated in service, get his wages, and also his service will be considered without any break, continuity. That
Here, question, Mr. Khare, prosecution was not at the behest of the department.
Yes, yes,
You were involved in a criminal case which is against the state.
yes.
Whether in such case of acquittal, you are entitled for full wages or not.
No, I am entitled for back wages from the date of acquittal. In the cases which are lodged by the department and found to be malicious, then I am entitled from back wages from the date of termination.
Yes.
In this case, I am claiming only from the date of acquittal, not from the date of my termination.
Yes.
In this case, Your Lordship, the acquittal order was passed on 7/3/2017 and I was reinstated on 8/3/2019.
Yes.
For the period of 2 years, I am claiming back wages. Only for 2 years, not beyond that. And that law is clear. Even, Your Lordship, in 2013 also,
Only question is of back wages. Continuously, you cannot challenge in this petition. You submit to the electrical decision. Only question is of back wages. अवतार सिंह में भी कुछ डिसाइड किया था इस बारे में?
सर इसमें सिर्फ केवल आर नारायण में डिसाइड किया था कि पिटिशनर राज नारायण में इसमें ये डिसाइड किया था कि द पिटिशनर इज एंटाइटल आफ्टर द एक्विटल. For the reason mentioned, we approve the judgment of the High Court of holding that the appellant shall be entitled for only back wages from the date of the acquittal on जो भी डेट रही हो till the date of
He is also claiming only from the date of
yes. If writ petition is only for the claiming from the date of the acquittal, then admittedly. But if he is claiming that the representation which has been given in the year of 2020 and that has been decided on 26/5/21, that writ appeal has not been maintainable.
Only appeal will be entertained only in respect of the back
One.
wages.
May I also mention Lordship 2 points further that on 7/3/17 the petitioner is acquittal. On 3rd of April 2017, first time the department get in knowledge that petitioner is acquittal. So the back wages may be started when he is informed the department that he is acquittal in this matter. That is the date is 3rd of April 2017. Number one. Number second point is as per the order of Honorable Court on 28 2017 after the 1 month.
From April 2017
कोई law है क्या? From the date of communication से हो. Law is that from the date of the order of acquittal.
Acquittal. Sir, that is my submission that because I am getting in the department getting the knowledge when he is entitled for it. If he is applying after 1 year or after 2 years of the acquittal, then he is not entitled for it. Number second point is that the honorable court is already passed it on October. If the appellant appeal is allowed, he shall be not entitled to pay any benefits for the half of the aforesaid period. That period may be also included in this matter, Lordship. जो 534 days है वो भी mention किया जाएगी. He is not entitled for that allowance for that period.
He shall be entitled for half of the period.
For half of the period. Yes, Lordship. That is in 534 days.
534 days.
And he shall not be for remaining days.
Yes.
Your Lordship, for that, Your Lordship, that direction is not for back wages first, Your Lordship, specifically. Second, if that kind of order is passed, that
any pecuniary benefits,
then it would be against the judgment and law settled.
We are not examining the order passed by this court.
Your Lordship,
we are not in appeal against the order passed by the same bench.
Yes, Your Lordship, but the intent of the court is that other
intent is very clear.
Back wages,
the delay of 168 days, 1068 days.
Out of that period, Your
has
Lordship,
been allowed only on the ground that he shall not be entitled to any pecuniary benefits for half of the period. We can't go beyond this.
Your Lordship, the law of limitation is not to bar any remedy to the petition.
Challenge it. Have you challenged this order in the Supreme Court?
Your Lordship, I'll file the application for recalling. Even otherwise, the final order is merged with the interim order.
Whether that is pending for recalling.
Your Lordship, I'll file that because
file it.
Yes, I will file.
I thought you have filed.
I will file it.
After arguments, we will not file. That order has.
Because otherwise, that would be against the law laid down by the Honorable Supreme Court.
Whatever is that order is there.
I'll file within Your Lordship.
Otherwise, appeal would have been dismissed on the ground of the delay itself.
Delay, Lordship, in 14/12/2018, Writ Petition Court has passed an order. At that time, there is no corona pandemic era is running. On 8th of March 2019, the petitioner is reinstated on the post.
Your Lordship, the Limitation Act applies only for seeing whether the delay is bona fide or not. Once the court has found that it is bona fide, then the remedy cannot be denied under the law of limitation. That is based on doctrine of leches, not a bar on the remedy.
Sir, he is not challenging this order before the apex court.
Validity of that order.
Yes, I'll file the application for. Otherwise, the order would be against the
After arguing half an hour, when the court pointed out this, then he said that he filed that application, going to file this application.
So they can prohibit my right to file application.
Sir, here.
Otherwise, we are allowing your appeal. Saying that you are entitled for back wages from the date of the acquittal till the reinstatement. But for this period, you will not be entitled for pecuniary benefits as per
Your Lordship, that would cause substantial.
At the outset, you could have asked for the time. You were knowing that this order is against you.
Your Lordship, I was of the view that the back wages proposition would not apply in this because
any pecuniary benefit court has could not have allowed the application for condonation of the.
Your Lordship, I have my unconditional apology. I file application and that would be per incurring to the Honorable Supreme Court order. Otherwise, also, Your Lordship, if
whatever is that. You want time to file?
Yes, Your Lordship. Within 3 days, I will file, Your Lordship.
Sri A.B. Khare, learned counsel for the appellant. Sri Himanshu Joshi, learned counsel for the respondents. Counsel for the at the request. We simply adjourn whatever you want. We will not observe anything. At the request of counsel for the appellant, appeal is adjourned for 4 weeks.
Your Lordship, next week it may be listed because already the.
If you will file, this will go before the same bench.
No, Your Lordship, recalling can come before the division bench.
Not recalling. After hearing, what is the question of recalling?
So now the matter, after filing that application, now the matter, application may be considered.
Review or modification of the order has to be filed.
Your Lordship.
Grounds of review and grounds of recalling are different.
Yes, Your Lordship.
There can't be application for recalling in this case.
Recalling because, Your Lordship, the period which the Honorable Court has mentioned from March 2020 till.
We are simply adjourning. Otherwise, we are going to allow your appeal. We are saying you that we will allow that.
Your Lordship, but that is a substantial period and substantial period stands in the court.
whatever
Only
you want, we are not
550
saying
days.
anything.
2 weeks time.
Special bench, etc. because that
वो
is
Friday को हर Friday it will be इसलिए that's why 2 weeks.
at the request of council for the appellant list after 2 weeks.
मतलब
Okay. Yes, नहीं है कोई. None for the appellant Sri
Mukesh Kumar.
Mukesh
Kumawat.
Kumawat.
Government.
Sri, yes, number 1 में. Yes, दीजिएगा. Yes.
सर ये सुप्रीम कोर्ट से 8 महीने में फाइनल डिसाइड करने का है. सुप्रीम कोर्ट से ऑर्डर हुआ, इसमें पेज नंबर 8 पे फाइल कर रखा आईए के साथ में. इसमें ये कि 8 महीने में फाइनल डिसाइड करने का है, तो फाइनल लाइन पे रखने की तैयारी है.
ठीक है, फाइनल हियरिंग में रख देते हैं. अभी तो पीरियड हुआ नहीं ना फॉर कंसिडरेशन, फ्रेश कंसिडरेशन.
जी मैम, अभी फ्रेश करनी है, अभी 2 महीने हुए अभी.
लिखिए MS शर्मिला शर्मा फॉर द appellant Sri Mukesh Kumawat, government advocate for the respondents heard on IA 13896 of 2022, which is an application for urgent hearing of the appeal in view of the order passed by the apex court dated 5/9/2022 in a special leave to appeal bracket में CRL bracket 1 number 5513 2022. In view of the order passed by the apex court, the appeal is directed to be listed final hearing in the week commencing. बताइए. January. In the month of January 2022. 23 कर दीजिएगा. Since the period for also heard on IA 13894 of 2022, इसको अभी विड्रॉ कर लीजिए क्योंकि अभी सुप्रीम कोर्ट का पीरियड नहीं एक्सपायर हुआ. देखिए, काउंसिल फॉर द appellant prays for withdrawal of the application. The application is dismissed as withdrawn. Yes.
Item number 2, I request for passover.
Passover. ठीक है, बुला लीजिए.
Passover.
Yes. Number 3.
Praying for 3 weeks time to argue the matter.
Okay, Sri Sapnesh Jain.
Siddharth Jain.
Sri Siddharth Jain for the appellant Sri Mukesh Kumawat, government advocate for the respondent state at the request of counsel for the appellant. The appeal, the hearing on IA for suspension of sentence is adjourned to 4 weeks.
4 weeks after 4 weeks.
Yes, 4 weeks.
So in this case, reply of the idea for suspension of sentence.
Yes,
2 weeks time में kindly
लिखिए. श्री आयुष अग्रवाल, counsel for the appellant Sri Mukesh Kumawat, GF for the respondent state, counsel for the state prays for and is granted 2 weeks time to file objection. Yes, Mr. Soni.
My lord, application for grant of temporary suspension of sentence on the ground of sickness of his wife, my lord.
Sickness of
his wife, my lord. She is suffering from some kidney problem as well as a liver problem, my lord.
Where is the IA?
My lord,
just IA 12405.
my lord.
One two four zero. You are convicted under
302, my lord.
302.
My lord. And the relevant document medical certificate is at page number 7, my lord. Her sonography report is also available, which suggests that
Page number 7.
7, my lord.
7 तो एप्लीकेशन ही है. What document you have filed?
Some medical papers. Initially, the documents were filed on 23rd of May 2022.
कोई भी डॉक्यूमेंट आपने नहीं दिखाया।
इनिशियली 23rd मई को किए थे, उसके बाद फिर से 26 अगस्त को भी फाइल किया।
एप्लीकेशन आपकी कौन सी है? एक आईए लगी है 12405, ये तो नहीं है टेम्परेरी सस्पेंशन की?
They are arguing in my lord item number 5.1 my lord. 5.1. Yes ma'am. 526/21.
5.1 8428.
Yes ma'am. 8428. They filed my lord some medical documents my lord, so we will verify those documents my lord.
Just a minute, we could not get the IA 8428. फ्लैग ही नहीं करते जो आइए इससे प्रवीण 8428 लिखे श्री मनोज कुमार सोनी, काउंसिल फॉर द अपीलेंट, श्री मुकेश कुमावत, गवर्नमेंट एडवोकेट फॉर द रिस्पोंडेंट स्टेट, heard on IA 8428 of 2022, which is an application for grant of temporary suspension of sentence on the ground of ailment of the wife of the appellant. Police staff counsel for the state place for and is granted 2 weeks time to verify the medical documents filed along with the application list after 2 weeks. हो गई वो देख उसमें नहीं मिली ना yes.
There should be an item number 6 and reply still awaited.
5 तो हो गए। वो तो कुछ ऑर्डर्स और पे है ये पे, उसका कोई मतलब नहीं। सस्पेंशन यस 6 में आपको टाइम चाहिए।
Reply
Reply is not required my lord. We have filed the reply my lord for co-accused persons my lord, so we will adopt that reply.
Will adopt. Yes. आप किसके लिए हैं?
Lordship, item number 6 है down here please. In item number 6
एक तो क्या है धाव
CRA number 7043.
हाँ यस और 541
हाँ IA नंबर है 11119। आप इसमें रिप्लाई के लिए बोल रहे हैं अडॉप्ट करना।
उनका कहना है 11118 में उन्होंने रिप्लाई दे दिया है। किसमें फाइल किया मिस्टर कुमावत?
Yes ma'am. In criminal appeal number 541/19 my lord. In item number 6.1 my lord.
इसमें फाइल कर दिया
Yes
है। इसका क्या करना है? 6.1 का आज बहस करेंगे कि बाद में? एक
टाइम दे
टाइम लिखिए आइटम नंबर 6 में लिखिएगा श्री
विजय शर्मा।
हैं?
विजय शर्मा।
विजय शर्मा फॉर द appellant श्री मुकेश कुमावत government advocate for the respondent state counsel for the respondent submits that the respondents have already filed objection to the application for suspension of sentence in connected criminal appeal 541 of 2019 full stop. The reply, the objection filed in the said appeal shall be adopted in the present appeal. Full stop. Counsel for the appellant prays for time to argue the application for suspension of sentence list after 2 weeks. सेम ऑर्डर कर दीजिए 6.1 में, उसमें सिर्फ इतना कर दीजिए काउंसिल फॉर द appellant prays for time to argue the application for suspension of sentence list after 2 weeks. Yes.
Item number WA 522, WA 540 and WA 640.
Yes.
I have to file reply, my lord. In 2 matters I have already filed, and in 1 matter 640. Today I am filing reply to their application for vacating stay. And then their second application is for urgent hearing, my lord. So we also
7.1, 7.2.
I have already filed.
You have already filed
the reply.
In which case you want to file reply?
7.4, my lord. WA 640 oblique.
Yes.
2020.
In these cases,
Yes.
we have filed an application for vacating stay
Yes.
and also for early hearing, the final hearing of the matter on the ground. My lord,
These
this
appeals
is,
are admitted?
No, my lord.
No.
No.
My lord, the case is like this, that the entire list it pertains to scheme number 94. Now, the petitioners herein, that is the appellants herein, they filed petition before the court saying that the unused land which is not there in the though part of the scheme, but it is unused, so that may be returned to us. That there was a state government's order which directed that the land be returned. However, that order was rescinded. They came before the court challenging that order, and in the writ appeal, their petitions were allowed with a direction that they may deposit some amount and their land be released. That has been assailed in SLP before the Honorable Supreme Court by the IDA, and also they have also challenged one of the conditions of the division bench order, and they are also in SLP. Now, during the interregnum period, the Act of 2014 came in force. So they requested the Supreme Court that their list with respect to the applicability of section 24(2) of the new Land Acquisition Act, this we have to agitate, so we can agitate before the High Court. The Supreme Court gave them this liberty with a further liberty to the parties to revive the matter, which is the main matter which is pending before the Supreme Court. So now, after the passing of the order by the single bench, they are in appeal, and we filed applications before the Supreme Court. The Supreme Court has revived the main matter and has listed the matter on 28th of November 2022 for final and further hearing. So now, my lord, this matter with respect to the applicability of section 24(2) to qua their claim is pending before this honorable court. The writ court has decided against them. Now this matter has come up before your lordship.
So what is
we
pending
want
before the Supreme Court?
the Supreme
Milord,
Court.
may I just point out, actually their going to the Supreme Court is premature. The Supreme Court said go and finish before the High Court. It's on the question of applicability of section 24. Now there is a WA provided. So until you exhaust that appeal, how do you, they did not mention before the Supreme Court that parties have filed WAs. In fact, that would have to be clarified. What they are now trying to seek is they consider themselves as a law unto themselves.
No, what matter is pending before the Supreme Court?
They have sought revival of their the original. Whereas, according to us, it can only go to the Supreme Court after we have finished through with the court.
This is not written anyway. This is not written
may
anyway.
not be written, but that is what the procedure is.
One by one, so that we can understand.
Lordship, kindly consider this, that we have submitted the
we
order.
wanted to know whether we have to wait for the decision of the Supreme Court on 28th,
no.
or we can fix it prior to 28th.
prior to 28, because my lord, this is the issue was.
So what issue is pending before the Supreme Court?
Before the Supreme Court, the issue was the original list was that the petitioner said that their land which is unused under the scheme, though part of this, yes, should be returned.
Yes.
There was an order of the state government which said yes, your land will be returned. However, that order was subsequently modified and cancelled. And against that, they preferred writ petitions before this honorable court. The writ court disposed of the petition, and in WA, that is in the appeal, the division bench directed that they will have to deposit a certain amount and the land will be returned to them. So against that, the IDF preferred SLP, and even the petitioners also went in SLP saying, assailing a portion of the order which said that they should deposit the amount. So now that issue is pending. My lord, the entire list belongs to such lands which is part and parcel of scheme number 94. The entire scheme has been implemented by building of the road, that is the ring road, and the scheme was for building of the road, and the land which was other adjacent land was for with respect to development of colonies and other structures which the IDF proposed to build. So now the petitioners are also before the Supreme Court, we are also before the Supreme Court. Then, my lord, 2014, the new act came into force. They said we want to agitate our claim with respect to the applicability as well as the lapse of the land acquisition for the provisions of section 24(2). So for that, the Supreme Court gave them the liberty. This order is also there. If your lordship pleases, I can read the order also, which says that having heard all the learned counsel, we are persuaded to dispose of these proceedings without entering on the merits by granting liberty to the landowners before us to pray for revival of the appeals in the event that order under section 24 of 2013 are adverse to their interest. So we have prayed for revival. We therefore permit the landowners to initiate proceedings in proper forum court seeking the benefit of section 24 of 2013 Act within 8 weeks from today. In the event that any landowner has already approached the High Court concerned, their plea under section 24 of the Act of 13 will be decided on merits. Now, section 24 claim has been rejected by the writ court. They filed WPs and they has been rejected. Now this matter is before your lordships. The main issue is still before the Supreme Court. Now the Supreme Court has on the revival application, wide its order dated 19th of September 2022 has revived all the petitions and said the civil appeals are hereby ordered to be restored to file. The miscellaneous applications stand disposed of, that is for revival, and the civil appeals are notified for further final hearing on 28/11/2022. So, my lord, what I submit is that this is a offshoot of the main list, which is pending before the Supreme Court. So, my lord, my prayer is for an early decision on this, an early hearing before 28/11/2022. And I don't think they are also adverse to it. Even, my lord, in case of Janak Prasad, they have their main thrust is.
If it is an offshoot of the main case.
Yes.
Let us take after the 28th.
No, my lord, then again, my lord, they will
again
say.
Question will come that matter is.
They will say, what they say is, they will say before the Supreme Court also that our list before section 24(2) is pending. My lord, they said that 24(2) says that if their land is, there is compensation is not paid or physical possession is not taken, we will get the benefit of section 24(2). So, if their claim is allowed, then definitely their land will be out of the scheme. And for that purpose only, we are saying that this list is also to be decided.
Yes.
Though the main issue is still pending before the Honorable Supreme Court. And furthermore, in Janak Prasad's case, Janak Prasad has only raised the
On merit we will consider. Mr. Bhargav, matter is pending before Supreme Court regarding return of the
original matter.
Yes.
That is the original matter.
Yes.
When the original matter came up for hearing, in the meantime, the new act was passed.
Yes.
So the judges felt that perhaps these matters would be covered by section 24.
Yes.
So they said you go to the High Court and finish it there and come back, and therefore reserve liberty to
We keep
revise
it
the
on
appeal. Now,
2nd December. So let us see that what is the outcome
Milord,
of
may I
the.
just point out something? Now, all this, what they are doing is entirely malified. Before the Supreme Court, what they should have pointed out was that while we have come straight to you, others have gone in the WA. Because
That we would not say what they have to say before the Supreme Court. Mr. Bhargav, we are keeping, because pleadings are not complete. You are asking time. Mr.
It is only
Bhargav.
for
I'm not
our
asking for
application
time.
for vacating stay and for early hearing. But in other matters, all matters are connected. And the council is also same in all the matters where the time is sought. They have already filed reply in and in all the matters the reply will be same, word to word same.
What is
because
the
in two
stay?
of
What is the stay?
the stay is status quo.
That is what the Supreme Court has
And
done.
Supreme Court had given them status quo only for 90 days till the passing of
No,
order. Yes, sir. I can read out. Yes. I can read out to your lordship that portion of the order also. And my lord, only submission is that it may be kept before 28. It may be kept before.
One
My
matter,
lord, because
main
this will
matter
definitely
is
have a bearing
for
on
return
the.
of the land.
My lord, this will have a bearing on the
If they
main
succeed
matter also.
before the Supreme Court regarding
Yes.
return of the land,
Yes.
then what question remains for the adjudication
My lord,
regarding
it is
24(2)?
either way. Suppose 24(2) claim is allowed, then also their land will be out of the scheme.
That's
And
right.
if
Since-
their
Why
land
have they
is.
gone to the Supreme
Arey, sir, ek minute. This is what I say. Suppose.
We are not
I said
deciding
suppose.
anything today. We keep it on 2nd December.
Instead, my lord, if your lordship keeps it
Nothing
before
will happen.
before 28. Before 28, because my lord, this will be the and this will have a bearing on the main issue also, my lord.
There is always
And for-
apex court never directs the High Court.
Yes.
We will look here.
High Court is not a subordinate court.
Nobody said so.
No, apparently
Nobody said so.
that's what it is.
Sri Bhargav, Senior Counsel with Sri Romesh
My lord.
Dave for the appellant. Sri Raj Saxena, Deputy Advocate General for the respondent state, MS Mini Ravindran
For
for
the
the
respond number 4.
ID इंदौर डेवलपमेंट अथॉरिटी कर दीजिएगा. लिखिए काउंसिल फॉर द appellant prays for time to file reply to the application for vacating of stay in WA 640 of 2022 full stop. It is also brought to the notice of this court that one SLP relating to return of the land of the original scheme of the same scheme is pending for consideration for
If I may interrupt your lordship for a second, all the SLPs, there are as many as
yes SLPs कर दीजिए.
SLPs, yes.
It is brought to the notice of the this
That
court
they have got all
that-
those SLPs revived apparently.
that the
Yes.
SLPs
Behind our
are
backs.
pending before the apex court
So much.
relating
Thank
to
you.
return of the land of the scheme of the same scheme which is fixed for hearing on 28/11/2022 full stop. Considering the same the matter is directed, these appeals are directed to be listed on 2nd December 2022. In the meantime, the pleadings shall be completed by the parties.
And the listing
Interim
on
order to continue.
2nd of December,
Second.
for final hearing, my lords?
Yes, yes. That's
I am appearing in 7.5 for the appeal.
parties की presence डाल दीजिए. पूर्वा महाजन. Yes. Okay.
So pray for 2 weeks time also.
Yes. लिखिए. श्री सुबोध चौधरी for the applicant. Shri, what's your good name?
Keshav Khandelwal.
Shri Keshav Khandelwal for the respondent.
Respondent 1.
for the respondent number 1. You want time.
लॉर्डशिप इसमें अनसर्व्ड है लॉर्डशिप, नोटिस नहीं सर्व हुआ है
Who has not been served?
दोनों को लॉर्डशिप
Parties who had been impleted R3 and R4.
R3 and R4.
दीपाली जाधव and रंजित करनाल.
The accused.
Okay. लिखिए, the notice on the respondents 3 and 4 are received back unserved. Let the fresh notices be issued to the respondents 3 and 4 on payment of PF within 7 working days, returnable within 4 weeks. Yes.
But application is on behalf of appellant number 3, KFG Malad, that is in criminal appeal number 9341/18.
Yes.
He has been convicted, Malad, for an offence under section
For
302.
suspension of sentence,
Yes, Malad.
IA 9960.
9960.
Just.
Malad, that is third application.
On behalf of
Appellant number 3, KFG.
KFG. Yes.
It is his third application, Malad.
Earlier rejected on merit.
No, Malad. It was withdrawn on 3/8/2021. That was for a permanent bail. It says learned counsel for the appellant submits that the appellant got payroll.
3/8/2021.
Yes, sir. That was in fact as the appellant was on payroll. Sorry. After the attendance of the lawyers, my lord, learned counsel for the appellant submits that appellant got payroll. Therefore, IA number may be permitted to withdraw with the liberty to renew it as per the need. Thereafter, my lord, on 17/6/2022, it was an application for temporary bail for taking care of a minor child. That was again, my lord, disposed of, rejected, but that was for a temporary period.
Yes.
My lord, the case is based upon 2 eyewitnesses.
You are convicted for
302 read with 149.
Yes.
And 147, 148.
Yes.
My lord, there are 2 eyewitnesses to the incident. Only 2 eyewitnesses to the incident. PW2 Shankar, my lord, has been declared completely hostile.
Yes.
He has not supported the prosecution story.
Yes.
PW1 Ranjan, my lord, the appellant was arrested on 27/4/2017.
Ranjan.
Yes, my lord.
PW1.
PW1 Ranjan.
Yes.
He had supported initially. His statement in chief was recorded on 17/10/2013.
Yes.
The present appellant was arrested on 27/4/2017.
Yes.
So when he was arrested, my lord, in chief was recorded as for the present applicant. If my lord would see
वो निकालिएगा कि स्टेटमेंट निकालिए. PW1.
जी.
रंजन.
और ये खिलाफ बोला था, बट ये नहीं था. Ranjan. But this statement, which is before my lord, that has been recorded on 17/10/2013.
Yes.
And at that time, the present appellant was not apprehended, he was not arrested.
Yes.
So if my lord would see after paragraph 36 जो इन चीफ हुआ है उसका पैराग्राफ 36 के बाद में आप देखेंगे
पैराग्राफ
आफ्टर पैराग्राफ 36
यस
it's a computerized typed statement.
Yes.
There is a note on the top. आज दिनांक 18/11 को शपथ दिलाकर विचाराधीन कैदी फलाना केवजी मंत्री के संबंध में मुख्य परीक्षण प्रारंभ किया. देन पैराग्राफ 1 बलट हिज इन चीफ वाज रिकॉर्डेड. मैं न्यायालय में उपस्थित केशर सिंह को नहीं जानता. आरोपी दूर सिंह केवजी मंत्री को भी नहीं जानता. घटना करीब 3 साल पहले की है. मैं घटना के समय त्यौहार पर खाना खाने गया था. दोपहर को 3 बजे थे. आरोपीगण ने किसी के साथ कोई घटना कारित की हो तो मुझे जानकारी नहीं. मैंने थाना सोरवा पर सूचना नहीं दी थी. प्रदर्श P1 की देहाती नालिशी पर हस्ताक्षर है. मैंने थाने पर रिपोर्ट नहीं लिखाई थी. थाना सोरवा पर रिपोर्ट मालदास ने लिखाई थी. पुलिस मौके पर आई थी. घटना का नक्शा पंचनामा P2 बनाया था. मेरे कथन लेखबद्ध किए थे फलाना फलाना. देन my lord he was declared hostile. And paragraph 4, my lord, paragraph 4, 5, he has completely denied the entire prosecution story.
Yes.
Then, my lord, the next statement is of PW 2, my lord, Shankar.
Yes.
Paragraph
he is also eyewitness.
He is also. These are the only two eyewitness, 1 and 2. PW1 रजन एंड शंकर. मैं न्यायालय में उपस्थित आरोपी गणों को पहचानता हूँ. अनुपस्थित आरोपी गण को भी पहचानता हूँ. फरियादी गण को भी पहचानता हूँ. मैं कालू सरदार को भी पहचानता हूँ. घटना दिनांक 16-17 माह पहले की है. घटना की शाम को सेवान का फोन आया. फोन किस संबंध में आया पता नहीं. उस समय मैं मास्टर की दुकान पर था. तब मुझे रंजन ने चलने के लिए कहा. मोटरसाइकिल पर रंजन के साथ गया. तब जीप खड़े हुए देखा था. जीप किस स्थान पर खड़ी थी मुझे नहीं मालूम. मैं वहां पर कुछ नहीं देखा. मुझे घटना के बारे में कुछ नहीं मालूम. मैंने हत्या होते हुए नहीं देखी. कालू सरदार की लाश पड़ी हुई देखी थी. मुझे नहीं मालूम पड़ा कि किसने मारा. सो ही वाज आल्सो डिक्लेयर्ड कंप्लीटली हॉस्टाइल.
Yes.
And my lord, the date of incident is 23/8/2012 at 9:30 in the evening.
Yes.
And exhibit P1 FIR. It has been registered on next day morning at 8 on 24/8/2018.
Yes.
PW 33, my lord, is the investigating officer.
Yes.
His name is Andreas.
Yes.
And paragraph 8, my lord, of PW 33.
PW 33 or 13?
33, sir. 33.
33. Yes.
Paragraph
Yes.
8 of the cross-examination is the investigating officer, the person who has lost the report.
Yes.
मैं पैराग्राफ 8 में रीड.
Yes, Mr. Singh.
मुझे घटना की पहली सूचना जब प्राप्त हुई उस समय मैं थाना सोरवा पर था. थाना सोरवा से घटनास्थल उकला फालिया 45 किलोमीटर पर है. फूलमाल चौकी से घटनास्थल का फालिया का लगभग 3.5 किलोमीटर की दूरी पर है. मुझे घटना के संबंध में दिनांक 23/8/2012 को रात में पुलिस अधीक्षक ने टेलीफोन पर दी थी. मैं रात में ही मौके पर गया था. रात में जब हम 8-10 पुलिस बल मौके पर सोरवा गए थे और फूलमाल चौकी पर अपने वाहन से घटनास्थल उकला फालिया गए थे. हमारे पहुंचने के बाद मौके पर जिला अलीराजपुर और अन्य थानों का पुलिस बल रात को ही पहुंच गया था. स्वतः का कुल पुलिस वालों बल की संख्या 20 से 30 होगी. पैरा 9 से हम लोग जब घटनास्थल पर पहुंचे तब कोई अन्य व्यक्ति घटनास्थल पर उकला फालिया पर मौजूद नहीं था. स्वतः का हमारे पहुंचने के कुछ देर बाद ही वहां के आसपास के लोग मौके पर आए थे. हम मौके पर पहुंचे तो कुछ लोग आ गए थे. उनसे हमारी कोई चर्चा नहीं, न पूछताछ की. देन क्वेश्चन हमारे द्वारा आसपास के लोग जो रात में मौके पर आए थे उनसे हमने पूछताछ नहीं की. इसका क्या कारण था? उत्तर, हम लोगों ने घटनास्थल पर उपस्थित लोगों से रात में पूछताछ नहीं की. लाश को ढूंढ रहे थे. पैरा 10 बलून, यह कहना सही है कि हमें रात को ही पता लग गया था कि कालू और सरदार की हत्या हो गई. यह कहना सही है कि हम लोग रात में उकला फालिया घटनास्थल पर आसपास चारों दिशा में तलाश किया था। तलाश करने में 2 से अधिक घंटे लग गए थे। यह कहना सही है कि रात में हमारे साथ मौके पर उपस्थित लोग भी लाश ढूंढने में सहयोग कर रहे थे। ऐसा नहीं हुआ कि मृतक दोनों के नाम है कि परिवार वाले रात में ही हमारे साथ लाश ढूंढने लगे। देन पैराग्राफ 11, यह कहना सही है कि रात में ही पुलिस बल ढूंढने के लिए मृतक कालू और सरदार के घर पर गए थे। हम लोग इनके परिवार के कोई भी पुरुष नहीं मिले थे, स्वतः महिलाएं मिली थी। मैं आज का समय नहीं बता सकता कि घटनास्थल रात में कितने बजे गया था। कहना सही है कि हमने घटनास्थल के आसपास बहुत छानबीन की। घटनास्थल पर हमें रात में ही कट्टा, खाली कारतूस और वस्तु नहीं मिली थी। यह कहना सही है कि हम पुलिस बल इस घटना की पूरी रात सर्चिंग करते रहे। रात में कुछ नहीं मिला। सुबह भोर होते ही हमें 2 लोग मिले। उन्होंने बताया कि फलानी जगह के पास में 2 लाशें पड़ी है और स्वतः का वो लोग राहगीर थे। आज मैं उनके नाम नहीं बता सकता। Then paragraph 12 also it's consistent with that. The police party reached in the night, but these eyewitnesses did not disclose. Though both the eyewitnesses have not supported the prosecution story.
Yes.
They have not named the present applicant as an assailant at any point of time.
Yes.
And if the eyewitness were not, though if they were in existence that seen the incident, जब रात को पुलिस वहाँ पे मौके पर पहुंची, they could have immediately disclosed, but they choose to keep quiet and they disclosed next day in the morning at 8 in the morning. And when their substantive piece of evidence was recorded in the court, Ranjan did not support when the present applicant was arrested, so he did not support as far as the present accused is concerned.
Yes.
And Shankar, right from day one, he was completely hostile.
Yes.
These are the only 2 eyewitnesses.
Two persons have been murdered.
2 persons died, Kalu and Sardar.
Yes, Kalu and Sardar.
Ji.
Yes.
And initially the chief PW1 had supported, but the present applicant was not arrested at that point of time. When the present applicant was arrested, uske liye again the in-chief was recorded, and in that in-chief has completely denied witnessing the incident. So absolutely there is no legal evidence for it.
Yes, Mr. Kumawa.
Yes, my lord, the initially case of the prosecution was that the present applicant, my lord, and other co-accused persons has caused gunshot injury, my lord, to both the deceased, my lord.
Yes.
And the postmortem was conducted by PW30, my lord, Dr. N.S.
PW?
Dower, my lord.
PW?
PW30, my lord, N.S. Dower, my lord.
Yes.
According to his postmortem reports, my lord,
Yeah.
both the deceased has died, my lord, due to gunshot injuries, my lord.
Yes.
And when this witness, my lord, PW1 Ranjan was examined, my lord, earlier before the trial court, my lord, he has fully supported the prosecution case, my lord, and deposed that the present applicant has caused gunshot injury, my lord.
Yes.
Thereafter, when the present applicant was again arrested, my lord, he is again examined before the trial court, and then he has turned hostile, my lord, for present applicant, my lord. And so far as that gun is concerned, my lord, that gun is recovered from the present applicant, my lord. And there's a FSL report is also, my lord, on the record, my lord. I'll just read out the relevant portion of that finding, my lord. Page number 42, my lord, of the judgment, my lord. Paragraph number.
Which para you are referring?
Yes, I am referring, my lord, paragraph number 69, my lord. On next page, my lord.
Probably page number 41 of the
41,
internal page 41, type page 41.
Yes, एक अन्य पिस्टल.
प्रदेश पी 51 की एफएसएल पैराग्राफ नंबर 69 प्रदेश पी 51 की एफएसएल रिपोर्ट के अनुसार प्रदेश सी मृतक सरदार की शर्ट, प्रदेश डी मृतक कालू की टी शर्ट, ई मृतक सरदार से संबंधित कॉटन, एफ मृतक कालू से संबंधित कॉटन, आई मृतक कालू के शरीर से प्राप्त छर्रे, जे टाटा मैजिक गाड़ी की बॉडी के अंदर फर्श की बाईं तरफ से पहुंचे गए कॉटन के, टाटा मैजिक की बॉडी के अंदर से फर्श की दाईं तरफ पहुंचकर लिया गया कॉटन, एन आरोपी 7 से जब्त बुशर्ट, एन 2 आरोपी 7 से जब्त पेंट, जो आरोपी बीकला से जब्त लोहे का फालिया. सो दीज आर द आर्टिकल मार्क, माय लॉर्ड. देयरआफ्टर, माय लॉर्ड, इन नेक्स्ट पैराग्राफ, माय लॉर्ड, एक अन्य पिस्तौल जो आरोपी केवजी से जब्त हुई है.
Yes.
रिपोर्ट प्रदेश पी 69 में जिसे पिस्तौल की जांच की जाना बताया, उसके बैरल की लंबाई 10.2 इंच होना, बताया तथा केवजी से जब्त देशी 12 बोर के कट्टे की जब्ती पत्रक में कुल लंबाई 10 इंच दर्शाया गया है। प्रदेश में 90 की रिपोर्ट में मृतक कालू के शरीर में पाए गए छर्रेम घटनास्थल से जब्त खाली कारतूस 2 भिन्न भिन्न पिस्तौल से फायर किया जाना दर्शाया गया है तथा ऊपर उल्लिखित अनुसार प्रदेश EC13 EC18 के फायरिंग पिन समान पाई गई हैं। MTCA1 से कंपेयर करने पर समान पाए गए। So, my lord, this FSL report corroborate the prosecution case, my lord. This is the scientific evidence, my lord, which can be not disbelieved, my lord, by this honorable court, my lord. It is not a case, my lord, where the eyewitness has completely turned hostile, my lord. Initially, they have supported the prosecution case, my lord.
Yes. And he alleged that the present appellant was armed with katta.
Yes, my lord. Yes, my lord.
And the cutter has been seized from him.
Yes, ma'am.
And as per the ballistic report,
yes, ma'am,
that it was fired by the same pistol.
Yes, ma'am. Yes,
ma'am. But this is section 273 CRPC. If my lord would be kind enough to look for a minute, my lord. What my learned friend is trying to say that in chief, when it was recorded in the year 2013, yes, that in chief will be read against me. Yes. But sir, आप 273 देखेंगे CRPC.
Yes.
It says, my lord, evidence to be taken in presence of the accused, except as otherwise expressly provided. All evidence taken in course of the trial or proceeding shall be taken in presence of the accused, or when his personal attendance is dispensed with in presence of the pleader. So, my lord, 273, when the accused was absconding, that in chief was never recorded in presence of the accused. He was arrested later on, and after paragraph 33, in chief was recorded when the accused was arrested while he was in custody. Yes. When earlier in chief cannot be read as for the accused because he was not present during the course of the trial. Yes. When in chief was again recorded of PW1, he has been declared completely hostile. He does not name me.
Yes.
So the in chief recorded on 17/10/2013, it cannot be read against me because I was not present during the course of the trial at that point of time.
Yes.
These are the technical grounds, my lord. These can be considered, my lord, at the stage of final hearing.
FSL report. Ballistic report. Mr. Singh.
Yes, sir.
Prima facie to have
So,
injury, उसकी death, gunshot injury है.
Sir,
the cutter is alleged to be seized from him.
But even if those eyewitnesses might have deposed against me, then also, my lord, the FIR 9:30 is the time of incident. That stated against me next day in the morning. My lord, if after a period of 10 years, if the benefit is given to me, that none of the eyewitnesses supported. None of the accused persons were apprehended. But that cannot be an imperating circumstance that I was absconding at the.
My brother is pointing out your conduct. That is also.
During trial, I was in custody, and when the in chief is recorded, when the substantive piece of evidence is recorded in the court, that has to be considered after my conviction. But substantive piece of evidence, the eyewitness account does not speak a single word against me.
Yes.
They have not supported the prosecution story when I was arrested.
लिखिए श्री विवेक सिंह, counsel for the appellant KFG.
Yes, madam. Yes,
appellant number 3 KFG. Shri Mukesh Kumawat, GA for the state, hard on IA 9960/2020 for suspension of sentence. The earlier application for suspension of sentence was dismissed as withdrawn. Full stop. Counsel for the appellant has been convicted and sentenced. ये ले लीजिएगा, अपील से ले लीजिएगा, लिखिए. As per the prosecution case, a report was lodged by Rajan stating that on 23/8/2012 at around 9 p.m. a mobile call was received by 7 on his mobile by one Kalu. Full stop. It was further stated that by Kalu that he along with one Sardar were coming from Baroda, and when they reached at Kunavat, two persons were sent to receive them. Full stop. The complainant and Shankar left on their motorcycle for Kunavat from Baroda. क्या बाड़ा है ये? From Bada at around 9:30 p.m. when the complainant and Shankar reached at Ukala Tekra Amrod, they saw Kalu and Sardar coming on a motorcycle. Full stop. A Bolero Jeep of Vesla was also standing, and all of a sudden people hiding in the vehicle came out. In the torchlight, complainant identified Dur Singh, Dudla, Bikla, Suresh, Diwan, Sevan, Narpat, Kesar Singh, Kevji, and 7 others. And it was alleged that they were all armed with the weapons. Full stop. The accused persons, after surrounding Kalu and Sardar, opened fire on them by guns and country-made pistol. Full stop. As a result of which they fell down. Sardar and Kalu were also assaulted by Palias. And when the accused persons approached towards complainant and Shankar, they managed to flee away from the spot on their motorcycle. Counsel for the appellant submit that there are 2 eyewitnesses, PW1 Ranjan and PW Shankar. Full stop. PW2 Shankar has turned hostile, and PW1 Ranjan has not supported the prosecution case so far the present appellant is concerned, and he was declared hostile. Full stop. Okay. Since the eyewitnesses have turned hostile, the appellant deserves to be granted benefit of suspension of sentence. Counsel for the state opposes the prayer on the ground that it is a case of double murder where 2 persons, Kalu and Sardar, have been murdered. As per the PM report
Yes.
by PW30,
Yes.
Dr. Rawat,
Yes. Dawar.
Both the deceased died due to gunshot injury and cut injury. Full stop. From the present appellant, a country-made pistol has been recovered. Full stop. As per the FSL report, Exhibit P1 and ballistic report, the said country-made pistol has been found to be used, and the cartridges भी जब्त हुए हैं.
Yes, ma'am. Yes.
And cartridges have been seized. Full stop. Thus, there is ample evidence. He further submitted that when the appellant was absconding, the statement of PW1 Rajan was recorded, and in the examination in chief, he has supported the prosecution case and made allegation against the present appellant that he was seen armed with country-made pistol. Full stop. After hearing learned counsel for the parties and taking into consideration the seizure of country-made pistol from the present appellant and the FSL report and ballistic report, no case for grant of suspension of sentence is made out. Full stop. The application is dismissed. रिक्वेस्ट नहीं है, डीबी के बाद ले लेंगे, हाँ? पहले रिक्वेस्ट ले लेंगे, अभी तो चलने दीजिए। यस
Item number 1 है request for 2 weeks.
देखिए, श्री शिवेंद्र सिंह रावत, लर्नर काउंसिल फॉर द एप्लीकेंट, श्री
I am for the objector.
for the objector, श्री चौधरी, हाँ? श्री सुबोध श्री पलाश चौधरी,
For the panel.
panel lawyer for the respondent state, Sri Saswat Seth, counsel for the objector, at the request of counsel for the applicant, list after 2 weeks.
Doshi, I am praying for 2 weeks time.
लिखिए, श्री विजय शर्मा, letter counsel for the applicant, Sri Palash Chaudhary, panel lawyer for the respondent state, at the request of counsel for the applicant, list after 2 weeks.
Doshi, pray for 2 weeks time.
Yes, आपका नाम?
योगेश प्रजापति.
श्री योगेश
प्रजापति.
प्रजापति, आपका है वकालतनामा है?
On the behalf of.
On behalf of Sri
Mr. Vikas Rathi.
Vikas Rathi, for the applicant, Sri Palash Chaudhary, panel lawyer for the respondent state, at the request of counsel for the applicant, list after 2 weeks. Yes.
एनसीपी का केस मतलब
Yes, Mr. Soni. नहीं है। श्री आप
जितेंद्र वाजपेयी.
Sri Jitendra Bajpayee, for the applicant, Sri Manoj Kumar, and none for the respondent, list in the next week. Yes, Mr. Sharma.
Please, Lordship.
Yes.
Lordship, second application under section 439, allegations under section 304B read with 34 of IPC. This is at the instance of husband, Lordship. Last time when the matter came before this honorable court, it was pointed out that the real sister of the deceased का examination complete नहीं हुआ. Now she has also been examined, Lordship. Now the position is that the father, real brother and this real sister, all these three witnesses, the star witnesses of the prosecution have been examined, Lordship. And if we look to their testimony, Lordship, it is crystal clear that no case, so far as this 304B is
You are the
concerned,
husband.
I am the husband, sir.
Yes.
And this is first application was withdrawn. The mother has also been arraigned as accused. She has been granted bail, Lordship.
Yes.
And now we are having only 3 साल का बच्चा है जो कि अभी दादी के पास ही रह रहा है. और पूरी गवाही अगर अपन देखें तो कोई भी इंग्रेडिएंट्स डाउरी की डिमांड को लेकर उसको परेशान किया, ये कहीं से कहीं तक अट्रैक्ट नहीं होता है. कस्टडी पीरियड भी सर ऑलमोस्ट 10 से 11 महीने के करीब हो चुकी है.
Yes.
लास्ट टाइम मेरे
Who have been examined?
सर फादर SPW1 सर, brother PW2 and now the
Father,
sister
mother.
also. Father, brother and sister.
Brother. Mother नहीं है क्या?
Mother
नहीं है.
Yeah, they have stated anything in their.
सर मैंने लास्ट टाइम भी सारे गवाही पढ़ी थी आपके सामने. आप इजाजत दें तो पिन पॉइंटेडली मैं फिर से पॉइंट आउट कर दूं. तो ऑन द कॉन्ट्ररी इट केम ऑन रिकॉर्ड कि दोनों के संबंध थे वो बड़े कॉर्डियल थे. दे यूज्ड टू विजिट दैट प्लेस आल्सो, मतलब ससुराल भी छोड़ के आता था.
गजानंद is father.
गजानंद सर फादर है. और गजानंद की भी गवाही अगर अपन देखते हैं तो उससे भी कहीं तक डाउरी के संबंध में कहीं सर वो नहीं हो पा रहा. लास्ट टाइम इन्होंने पॉइंट आउट किया था कि सिस्टर का हो रहा. सर गजानंद का मैं बता देता हूँ सर.
फादर ने पैरा 2 में कहा तो है.
सर ये क्रॉस एग्जामिनेशन जो हुआ है सर उसका, आई वुड लाइक टू नो लॉर्डशिप काइंड इंटेलिजेंस ऑन द क्रॉस एग्जामिनेशन. उसमें सारी की सारी चीजें उसने एडमिट करी है. आई जस्ट पॉइंट आउट सर ये पेरा 6 से आई एम रीडिंग सर, ये कहना सही है कि मेरी बेटी कल्याणी से मेरे और मेरे परिवार के मध्य बातचीत होती रहती थी। रियांश कल्याणी और आनंद का पुत्र होकर मेरा नाती है। कल्याणी की जो डिलीवरी हुई थी देवास में उसके ससुराल में हुई थी। यह बात सही है कि कल्याणी का इलाज आनंद एवं उसके पेरा 6 आई एम सॉरी पेरा 8 सर, पेरा 8। यह कहना सही है कि मेरी बेटी कल्याणी से मेरे और मेरे परिवार के मध्य बातचीत होती रहती थी। रियांश कल्याणी और आनंद का पुत्र होकर मेरा नाती है। कल्याणी की जो डिलीवरी हुई थी वो देवास में उसके ससुराल में ही हुई थी। यह बात सही है कि कल्याणी का इलाज आनंद एवं उसके परिवार वालों ने देवास व इंदौर के अच्छे डॉक्टरों से करवाया था। सर पेरा 9। यह बात सही है कि शादी के समय मेरे द्वारा तथा मेरे परिवार वालों के द्वारा आनंद के घर को एवं उसकी आमदनी को परख लिया था और उसके द्वारा भी मेरे तथा मेरे परिवार की वास्तु स्थिति को जान लिया था। यह बात सही कि आनंद का परिवार भी सामान्य परिवार से आता था तथा मेरा परिवार भी सामान्य परिवार की श्रेणी में ही आता था। यह बात सही कि पहली बार लड़की को लिवाने के लिए हमारे परिवार में से कोई भी नहीं गया था, अपितु आनंद छोड़ने के लिए बालाघाट आया था। स्वतः कहा कि मेरी पत्नी नहीं है तथा और कोई नहीं थे, इसी कारण आनंद मेरी पुत्री को छोड़ने आया था। यह बात सही कि खुशी खुशी दोनों आए थे एवं खुशी खुशी दोनों चले गए थे। यह बात सही कि दूसरी बार भी आनंद एवं कल्याणी साथ आए थे, खुशी खुशी आए थे, खुशी खुशी विदा हो गए थे। आनंद 3 बार कल्याणी के साथ मेरे परिवार में आया था, तीनों बार दोनों खुशी खुशी आए, खुशी खुशी विदा हो गए। यह बात सही है कि उस समय तक कल्याणी ने मुझे कोई दुख की तकलीफ की बात नहीं बताई थी। मेरे आनंद के परिवार में 3 बार आना हुआ था। मेरा आनंद और उसके परिवार वालों ने अच्छे से ध्यान रखा था। कल्याणी भी काफ़ी खुश नजर आ रही थी। कल्याणी पढ़ी लिखी थी, उसने आर्किटेक्ट का कोर्स किया हुआ था। मेरी जब भी उससे बात होती थी थोड़ी सी बात करके अपने बेटे से बात करवा देती थी। कोरोना काल का लॉकडाउन खुलने के पश्चात मेरी बेटी कल्याणी बालाघाट से मेरे घर आई थी। कोरोना काल के बाद भी 2021 में कल्याणी खुशी खुशी आई, खुशी खुशी ही हमारे घर से गई थी। उसने कोई बात उस समय भी नहीं बताई थी। आज मैं ये नहीं बता सकता कि रात्रि पर बालाघाट से वापस आने के पश्चात दीपावली पर मैं फिर वापस आया था। ये बात सही है कि मैं दीपावली के पश्चात देवास आया था और कल्याणी को लेकर उसकी बेटी के घर इंदौर गया था। उस समय भी खुशी खुशी कल्याणी उसके घर से मेरे साथ इंदौर गई थी। यह बात सही कि कल्याणी को उसके पति का एवं उसके परिवार वालों का बहुत ध्यान रखती थी। साक्षी से ये पूछे जाने पर कि आनंद कल्याणी का बहुत ध्यान रखता था, जिसके जवाब में साक्षी का कहना है कि अंदर की बातें मुझे नहीं मालूम। देन सारे के सारे ओमिशन पैराग्राफ 17 में है। मैंने अपने पुलिस कथन D1 में बता दिया था कि मैंने अपनी बड़ी पुत्री दीपाली जो इंदौर में रहती है और पुत्र रोहित को मैंने फ़ोन लगाकर बात बताई। उक्त बात कथनों में नहीं लिखी तो कारण नहीं बता सकता। पैरा 18 में फिर सर ओमिशन है। ये बात सही कि कभी भी आनंद ने मुझसे पैसों की मांग, ये सर पैराग्राफ 18 काफ़ी इंपॉर्टेंट है। यह बात सही है कि कभी भी आनंद सर प्रेजेंट अप्लीकेट मुझसे पैसों की मांग नहीं की। स्वतः का मेरी पुत्री की मौत से पहले की थी। यह कहना गलत है कि आनंद मेरी पुत्री को प्यार करता था, उसका ध्यान रखता था, ये कहना गलत है। कांताबाई ने कभी मेरी पुत्री को प्रताड़ित नहीं किया, ये कहना गलत है कि मैं और पुत्री की जान के गम में आनंद और कांताबाई के खिलाफ झूठे कथन कर रहा हूँ। यह बात सही है कि कल्याणी का पुत्र रियांश आज भी अपनी दादी और अपने पापा के पास ही रहता है। यह बात सही कि कांताबाई, आनंद और परिवार के अन्य सदस्य रियांश को अच्छे से ख्याल रखते हैं। ये कहना गलत है कि पुलिस के द्वारा लिखी गई असत्य घटना के उसके मैं कह रहा हूँ। So now treating the case as it is, let's see how the ingredients of section 304B would attract in this case, sir. 2 से 3 साल का अरसा हो गया था सर। रोहित का भी बयान हुआ है, उसकी भी गवाही मैंने आपके सामने पेश करी है। उसकी गवाही से भी कहीं से कहीं नहीं होता। और लास्ट डेट पे जब मैटर आपके सामने आर्ग्यूमेंट पे था तो मेरे लर्नेड फ्रेंड ने पॉइंट आउट किया था कि इसकी सिस्टर का बयान कंप्लीट नहीं हुआ। नाउ द पोजीशन इज दैट सर, मैंने उसकी गवाही भी आपके सामने पेश कर दी है। शी हैज आल्सो बीन एग्जामिन्ड और उसकी गवाही को भी अगर अपन स्क्रूटिनाइज करें तो कहीं से वो नहीं होता। तो नाउ लुकिंग टू द पीरियड ऑफ इनकार्सरेशन विच द एप्लीकेंट इज अंडरगॉन सो फार, मटेरियल विटनेस हैव ऑलरेडी बीन एग्जामिन्ड एंड देयर इज नो apprehension that the same may be influenced or will be been over lordship, that is also not there. तो इन सब परिस्थितियों में मैं अम्बल की सब्जेक्ट टू आउटकम ऑफ ट्रायल लॉर्डशिप। और एलिगेशन ये है कि ही लॉ मतलब एक्सप्लिसिट कोर्ट स्टेटमेंट में सब्सटेंटिव एविडेंस में तो वो बात भी नहीं आ रही। इनिशियल एग्जामिनेशन में इनका ये कहना था कि ही लॉस हिज जॉब ड्यूरिंग दिस कोरोना पीरियड, तो उसके लिए अपना खुद का काम चालू करने के लिए पैसे की डिमांड कर रहा था। तो वो तो अदरवाइज आल्सो विल नॉट कम अंडर द एम्बिट ऑफ डाउरी सर। वो मैंने जजमेंट भी आपके पास सुप्रीम कोर्ट का पेश किया हुआ है। छोटे बच्चे को कोई देखभाल करने वाला नहीं है, दादी के पास है, 10-11 महीने का पीरियड इज ऑलरेडी सफर्ड सर। आई एम सॉरी।
Yes, Mr. Chaudhary.
Not the statements of the sister on which the matter was being postponed for hearing and was being deferred. Her statements has been given off, and if my lordship would go through the statements, the story comes to the very effective and a very corroborative manner that when the case was being launched, the FIR was being launched, no factual changes have been made. The witnesses have been remained the same and have stated grimly with regard to all the allegations. With regard to the ingredients of 304, my lord, it has been came out, and as the demand was being there, in the circumstantial position, she committed suicide by hanging. And the purview of the legislature was also being intended for this particular section with this regard, that as in the circumstances in 7 years of marriage, such scenarios happen, so would be responsible. So there has been direct allegation with regard to the demanding of the dowry, my lord.
Your sister also says कि he used to beat him.
Yes, ma'am.
Yes. कहाँ पे बता दीजिए?
Father ने तो कहा है।
रिलेवेंट पैराग्राफ है, इसके चीफ का 4th पैराग्राफ है। मेरी बहन जब भी मुझे फ़ोन लगाती थी वह फ़ोन पर रोती रहती थी। मेरी बहन कहती थी मुझसे दहेज व पैसों की मांग आरोपीगण द्वारा की जाती है, डिलीवरी के लिए भी ताना मारती हैं। अभियुक्त द्वारा कुछ समय बाद मेरी बहन के बच्चे को भी उससे दूर कर दिया गया था। उसकी सास कांताबाई बच्चे को अपने साथ लेकर रात में सोती थी। अभियुक्त गण आदन फड़के मेरी बहन के साथ शराब पीकर मारपीट करता था व दहेज के लिए परेशान करता। बिल्कुल स्पेसिफिक एलिगेशन है योर लॉर्डशिप। और ये जो कोरोना में इसकी जॉब जाने की बात है, ये पैरा 13 जो क्रॉस एग्जामिनेशन का है दीपाली काले का, उस पर स्पेसिफिक क्वेश्चन पूछे हैं डिफेंस काउंसिल ने। साक्षी से पूछे जाने पर कि कोरोना काल में अभियुक्त आनंद की नौकरी चली गई थी क्योंकि उस समय पूरे देश में कोविड था, जिसके जवाब में साक्षी का कहना है कि कोरोना 2020 में आया था, अभियुक्त आनंद की नौकरी 2019 में ही जा चुकी थी। यह कहना गलत है कि 2019 में कोरोना आया था और कोरोना अवधि में ही उसकी नौकरी गई थी। इसी बात को इन्होंने बार बार रिपीट किया। 2019 एवं 2020 में कोरोना काल की अवधि थी। फिर उसने साक्षी ने उत्तर दिया है कोरोना काल की अवधि के पूर्व ही आनंद की नौकरी चली गई थी। अगेन वही क्वेश्चन फिर से पुट किया है कि 2020 की अवधि कोरोना काल की थी। फिर उसने आंसर दिया कि नहीं, 2019 की अवधि कोरोना काल की नहीं थी। इसे लगातार ये घुमाया जा रहा है कि उसकी सर्विस चली गई थी इसलिए उसने दुकान खोलने के लिए पैसा मांगा। इसके आगे भी पैरा 15 जो है उसका, साक्षी ने स्वतः कहा कि मेरी बहन की डिलीवरी शासकीय अस्पताल में, ये उसके टॉर्चर की एक कहानी है कि हॉस्पिटल में करवाया जाना था। मेरी बहन का बीपी बहुत ज़्यादा बढ़ गया था, इसलिए शासकीय अस्पताल में यह कहा गया था कि यहाँ हम डिलीवरी नहीं करवा सकते, आप कहीं और डिलीवरी के लिए ले जाओ, इसलिए उसे मजबूरी में प्राइवेट अस्पताल में भर्ती किया था। इनका एलिगेशन कि उसे बहुत अच्छे से रखते थे। ये भी जो इनका कहना है कि बार बार इन्होंने पूछा कि राजी खुशी आई थी, राजी खुशी आई थी। ये सारे सिनेरियो पीछे थे। इसके बाद पैरा 17 में भी है, उसने साफ साफ कहा है, यह कहना गलत है कि उस समय कल्याणी ने सब राजी खुशी होना बताया था। यह कहना भी गलत है कि उस समय कल्याणी राजी खुशी वापस गई थी। इसके बाद योर लॉर्डशिप पैरा 18 है क्रॉस एग्जामिनेशन का। वहाँ पे भी इसने बताया है कि किसी रिश्तेदार के यहाँ शादी में गए थे, वहाँ पे इसने अपने पिता को बात बताई थी। पैराग्राफ 18 के मैं पूरा ही पढ़ देता हूँ। साक्षी से यह पूछे जाने पर कि उस समय कल्याणी ने क्या बताया था, जिसके जवाब में साक्षी का कहना है कि हमारी माँ ने हमें यह सिखाया है कि परिवार की कोई बात बाहर वालों को नहीं बताओ। मेरी बहन ने मेरे से ही अपने परिवार की बात बताती थी, किंतु जब वह शादी में आई थी तो मेरे पिताजी व भाई को परेशान होने वाली बात बताई थी।
पिताजी और भाई दोनों का बयान मैंने पढ़ा जिसमें कहीं से कहीं तक वो नहीं आया। और इस टाइप ये वी आर ऑन बेल एंड दिस टाइप ऑफ डिटेल। और जो सबसे पहला एलिगेशन सर आपने लगाया है, काइंडली सी पैराग्राफ 28 ऑफ दिस वेरी विटनेस सर, जो आपका कहना है ना कि डाउरी के लिए परेशान कर रहे थे। आपकी इजाजत से सर पैराग्राफ 28 आई एम रीडिंग। मैंने अपने पुलिस कथन प्रदेश D3 में पुलिस को यह बताया था कि आरोपीगण दिन रात मेरी बहन को ताने मारते हैं। मैंने अपने पुलिस कथन प्रदेश D3 में पुलिस को यह नहीं बताया था कि शादी के 3 माह बाद मेरी बहन कल्याणी गर्भवती हो गई थी, 8-9 बाद मेरी बहन को परेशान किया था। मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था, लेकिन उस समय उतना परेशान नहीं किया था क्योंकि वो गर्भवती हो गई थी। मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था कि मेरी माँ की मृत्यु हो गई थी, वो मैं भी नौकरी करती थी, इसलिए मेरी बहन की डिलीवरी देवास में हो गई थी। मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था कि मेरी बहन को ऑपरेशन से डिलीवरी होने के कारण परेशान किया जाता था और कहा जाता था कि तेरी डिलीवरी में कितना पैसा लग गया। पैराग्राफ 29 सर, मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था कि मेरी बहन जब भी फोन लगाती थी तो वो फोन पर रोती रहती थी। मैंने अपने पुलिस कथन D3 में पुलिस को यह भी नहीं बताया था कि मेरी बहन कहती थी कि मुझसे दहेज व पैसों की मांग आरोपीगण द्वारा की जाती है। मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था कि डिलीवरी के लिए उसकी सास उसे ताना मारती थी। मैंने अपने पुलिस कथन D3 में पुलिस को यह नहीं बताया था कि अभियुक्त द्वारा कुछ समय बाद मेरी बहन के बच्चे को भी उससे दूर कर दिया गया था। मैंने अपने कथन पुलिस D3 में पुलिस को यह नहीं बताया था कि अभियुक्त आनंद फड़ के दहेज के लिए मेरी बहन को परेशान करता था। सर पैराग्राफ 30 अगेन में काइंडली बी सीन। मैंने अपने पुलिस कथन D3 में पुलिस को यह बताया था कि अभियुक्त धीरे धीरे शारीरिक रूप से प्रताड़ित करने लगा था, किंतु मेरे पुलिस कथन D3 में अगर उक्त बात न लिखी हो तो मैं कारण नहीं बता सकती। मैंने अपने कथन D3 में पुलिस को यह नहीं बताया था कि मेरी बहन का 3 बार ऑपरेशन भी करवाया गया था जबकि उसकी स्थिति ऑपरेशन करने की हालत में नहीं थी। तो ऑल दिस थिंग्स सर ये इम्प्रूवमेंट है, ओमिशन है। विद ग्रेट रेस्पेक्ट टू माय लर्नेड फ्रेंड लॉर्डशिप, दिस इज द बेसिक कंसेप्ट। हाउ कैन द एविडेंस कैन बी रीड इन आइसोलेशन सर when all these things are there? At that time he was opposing कि अभी उसका बयान होना बाकी है and there is possibility कि हम उसको ट्यूटर कर देंगे, टेम्पर कर देंगे। And now the evidence which come on record, so he is reading only the examination chief. He is not taking care of what had happened in cross examination. All this omission goes to very root of the case and clearly goes to show that a false and concocted case has been constituted.
लॉर्डशिप में पैरा 6 और 7 चीफ का ये भी बहुत ज़्यादा इंपॉर्टेंट, ये मैं एक बार रीड कर दूं। आरोपी की नौकरी छूटने के बाद आरोपी ने मेरी बहन का खाना पीना भी हराम कर दिया था। मेरी बहन को समझाती रहती थी कि सब ठीक हो जाएगा, परंतु दिन प्रतिदिन हालत बदतर होती जा रही थी। आखिर मेरी बहन ने मेरे पिताजी को बता दिया कि आपने विवाह में कोई दहेज नहीं दिया, वह दहेज और रुपयों की मांग कर रहा है। उसके बाद मेरे भाई और मेरे पिताजी ने आरोपी आनंद को समझाया कि हम लोग दहेज नहीं दे सकते। यह सब चलता रहा और वह नहीं माने। फिर दिनांक 28/11 जिस दिन सुसाइड कमिट हुआ, 28/11/2021 को मेरी बहन कल्याणी ने 3-3:15 बजे मेरे फ़ोन पर बताया कि आरोपी आनंद मुझे 2 दिन से मारपीट कर रहा है और मुझे बोल रहा है कि अगर यदि तुम दहेज नहीं लाई तो मैं तुम्हें बच्चा भी नहीं दूंगा।
मिस्टर शर्मा है नहीं एलिगेशंस हैं।
सर मेरा बड़े ही अदब से ये गुजारिश है कि मेरे जो लर्नेड फ्रेंड जो पॉइंट आउट कर रहे हैं वो सारा का सारी चीज़ें न तो फादर कह रहा है और न सारी चीज़ें भाई कह रहा है। ये इसका पूरा बयान जो है 161 के जस्ट कॉन्ट्ररी है। तो ये बयान प्रिवेल ही नहीं करेगा सर, मेरा ये नहीं लगता। और उसके बाद भी अगर लॉर्डशिप इज नॉट इंक्लाइंड तो इसको आप कुछ वो कर दें, क्योंकि अननेसेसरी 2 महीने 3 महीने क्योंकि मटेरियल गवाह सारे हो चुके हैं। अब देयर रिमेंस नथिंग।
काउंसिल फॉर द एप्लीकेंट श्री पलाश चौधरी, पैनल ऐड फॉर द रिस्पोंडेंट स्टेट श्री अभिषेक तिवारी for the learned counsel for the objector. After arguing for some time, learned counsel for the applicant prays for withdrawal of the application. The application is dismissed as withdrawn.
Sir, trial court में kindly direct to expedite.
The trial court is directed
already
to
more than a
expedite the trial. Yes.
Item number 6 में आयोग को कॉल किया था, वहाँ से शायद इज प्रेजेंट।
For what purpose?
The two witnesses did not turn up before the learned trial court and they are stating इनका खुद का प्रति जवाब है नोटिस का पेज नंबर 2526 पे कि विटनेसेस तामिली से बच रहे हैं, वो समन्स तामिल नहीं होने दे रहे हैं।
We will take up after break. Sir.